EddieBlockFilms, EddieBlockFilms Show, EddieBlockFilms, EddieBlockFilms, EddieBlockFilms Show, EddieBlockFilms Show.
Yeah, we watching Eddie, getting facts ready, keeping all the cameras steady, audio ready, so unlock, yep, in a low, Patriots prepare for the Eddie Block Show.
EddieBlockFilms, EddieBlockFilms Show, EddieBlockFilms, EddieBlockFilms Show, EddieBlockFilms, EddieBlockFilms.
What's going on, everybody? Hope you're having a good day. You ready for this trial to begin again? Let's get it going here. I thought I was pretty close to where it should be starting.
Motion.
Alright, here we go.
On a motion from witness Maurice Hall. Mr. Hall, could you spell your names? We've gotten different spellings on your name.
The correct spelling for you guys will be MORRISHALL.
All right. And representing Mr. Hall today, note your appearances. And Mr. Hall, your attorneys are present. When they address the court, they're going to go to the podium, so you should be able to see them at that time. But obviously we are not in a position where you can consult privately with them today, but you've had a chance to talk to them. Is that correct? That's a yes?
Yes.
All right, thank you. All right, this is Mr. Hall's motion as a witness to quash the subpoena. Who would like to address it? Cousins, if you would. And you can take off your mask if you'd like.
Thank you, Judge. Good morning, Your Honor.
Morning.
Mr. Hall has been subpoenaed as a witness in this case by both the prosecution and defense. Defense counsel in their opening statement specifically named Mr. Hall and told the jury that they intend to call him and previewed what that testimony they believe would be. So in order to avoid any kind of delay or interruption in these proceedings, I notified all parties that Mr. Hall would be invoking his Fifth Amendment privilege against self-incrimination where he called to testify. I then subsequently filed my notice, my motion to quash the subpoena. Your Honor, at this point in time, Mr. Hall has no immunity. He has been provided no immunity, no protection for his testimony whatsoever. And because of that, Mr. Hall is invoking his Fifth Amendment privilege against self-incrimination in several key areas of questioning that we believe he would face were he to be called to testify.
Well, let's stop you there. You said on certain areas that he would testify to. So there are some topics that would not incriminate him. Is that correct?
Your Honor, I cannot envision any topics that Mr. Hall would be called to testify on that would be both relevant to the case that would not incriminate him.
Well, that's ultimately the court's decision, correct?
Yes.
Okay. And that's on a question-by-question basis. Is that correct?
Yes, Your Honor.
Okay.
Yeah.
Go ahead. I interrupted you.
No, that's okay, Judge. And just for brevity, I wanted to outline those areas that I believe Mr. Hall may face questioning. The first area where he would be invoking his privilege against self-incrimination is any activities that took place on May 25th, 2020, both before and after police arrived.
Okay.
Mr. Hall's testimony in these matters would specifically put him in the position of being in very close proximity to Mr. Floyd. There's an allegation here that Mr. Floyd ingested a controlled substance as police were removing him from the car. A car, by the way, that has been searched twice, and to my understanding, drugs have been found in that car twice. This leaves Mr. Hall potentially incriminating himself into a future prosecution for third-degree murder. And specifically, that's 609.195 subdivision B. And that statute, as the court is well aware, covers third-degree murder liability for someone who is involved in drug activity that eventually leads in an overdose. And that statute is broad, Judge. It does not just include the situation where A sells drugs to B, B then succumbs to an overdose. In fact, it includes any activity directly or indirectly, unlawfully selling, giving away, bartering, delivering, exchanging, distributing, or administering a controlled substance classified as Schedule 1 or 2. So that statute is broad, Judge, and it has been interpreted broadly by Minnesota courts. Again, it's not just that A and B situation. In fact, anyone who can be pointed to as a link in the chain of distribution, someone who prepares drugs for someone else, someone who acts as a go-between, can be implicated in third-degree murder. And so any of the activities that Mr. Hall would be testifying about throughout that day, and including before police arrived on May 25th, 2020, could potentially incriminate him in that charge, not to mention drug sale and drug use. Additionally, the other area of testimony in which Mr. Hall would be invoking his Fifth Amendment privilege is any personal knowledge that he has of drug use by George Floyd up until and including May 25th for the exact same reason, Judge. It leaves him open to exposure on a potential future third-degree murder charge. Any testimony regarding his activities with Mr. Floyd could leave him open to potentially incriminating himself.
All right. I think what I'm going to do is ask Mr. Nelson to list for the court the topics and areas and whether there's something outside of what you just outlined. So, because maybe there is some common ground there. So if you could just switch places.
Your Honor, it would be the defense intent to inquire of Mr. Hall as to the following. Certainly, any events leading up to Mr. Hall and Mr. Floyd's arrival at Cup Foods earlier in the day, where they were, what they were doing. Mr. Hall's interactions with Mr. Floyd in the Cup Foods, including whether either party gave the other a counterfeit bill. Whether or not Mr. Hall gave, sold, or otherwise provided Mr. Floyd with controlled substances. Specifically, whether Mr. Floyd, his behavior in the car, Mr. Hall previously described that Mr. Floyd was falling asleep, that it was sudden. I would ask him questions about Mr. Hall's previous statements to law enforcement that Mr. Floyd had indicated he did not intend to, or that he was planning on taking these pills later when they got home, implying that Mr. Floyd took them before they left. Mr. Hall described seeing Mr. Floyd go for the ignition when the police arrived, so his behaviors in the car at the time police arrived. Mr. Hall, I would intend to ask him about giving false names to police officers after they were intervened, after the police intervened. Mr. Hall is seen on a security camera taking something out of his backpack and throwing it. I would ask him about those and what it was that he threw. And I would also ask Mr. Hall about his decision to leave Minnesota immediately after this incident and his subsequent apprehension by the Texas Rangers.
Well, let me focus on a couple things. I think you would agree that any questions that he answers about the counterfeit bill falls within could incriminate him. Would you agree with that?
Yes.
Also, the false information he gave to the police, he would have a legitimate invocation of his Fifth Amendment rights there as well.
Yes.
And what he took out of the backpack, that's a legitimate Fifth Amendment privilege to invoke there.
Yes.
Flight as circumstantial evidence of guilt, you would agree that his fleeing to Texas, if you went into motives as opposed to simply traveling to Texas, that could be considered incriminating. Would you agree with that?
Yes.
Use and possession of drugs by both of them during that day, that could incriminate him based on counsel's representation. Would you agree with that?
Yes.
It seems like just about everything that you want to ask him, except the following. He would have a legitimate right to invoke his Fifth Amendment rights against compelled self-incrimination. And that being how George Floyd appeared when he was back in the car and the falling asleep suddenly. Would you?
Well, I mean,
And I'm sure counsel is going to say that that's incriminating, but
I do not believe that that in and of itself incriminates Mr. Hall in terms of a description of Mr. Floyd falling asleep. But the implication being that because fentanyl was found in Mr. Floyd's system, and it causes a person to fall asleep, that would be ostensibly connected to ingestion of controlled substances. So, I mean, remotely perhaps, I would argue, but not in and of itself.
all right. Ms. Cousins, would you? And unfortunately, you don't have the benefit of having sat through all the testimony, but it appears that this would be a proper invocation of his Fifth Amendment rights for just about everything Mr. Nelson was talking about. The one exception appears to be his observations sitting in the passenger seat of the car as how Mr. Floyd appeared, that he was falling asleep and that it happened suddenly. Very narrow. And the reason why I say that is because we have kind of a parallel testimony from a clerk in the store who said Mr. Floyd appeared good-natured, seemed to be having a good day, but he did appear to be high. I don't even think I'd allow counsel to ask whether he appeared high, because that could have formed some kind of opinion and infer a basis that he knew why he was under the influence. But it seems to me that just his description, Mr. Hall's description of, like the store clerk, is not going to incriminate him if there's no questioning about how he had, why he fell asleep, why he thinks he fell asleep, that there were drugs in the car, that he knew there were drugs in the car, that there was any possession by Mr. Floyd of drugs that day that he saw. If we totally avoid the word drugs and just have Mr. Hall say, I was the passenger in the car, which is already clear. There's video and evidence, just for your knowledge, that Mr. Hall is in the passenger seat and is removed by the police. Beyond that, if that were established that he was the passenger when the police came up to the car, what was Mr. Floyd's condition immediately that he observed immediately before that? Would you agree that that's not incriminating if we keep all the mention of drugs or why or anything like that?
No, Your Honor, I do not agree that.
How would that, when it did not incriminate the clerk who said he thought he was high, how would it be that Mr. Hall saying that would incriminate him?
Well, because first of all, Judge, the inquiry is not what evidence is in front of the jury. What testimony have they heard?
No, I'm just using that as an analogy on how that certainly didn't incriminate the store clerk by saying, well, he appeared high. Well, Mr. Hall saying, well, he appeared like he was falling asleep and it happened suddenly. Without anything else, seems to be a parallel type evidence. So I was using it as an analogy.
I understand, Judge, but the whole point here is to prevent Mr. Hall from incriminating himself. And him even answering that question that he was in the car puts him in very close proximity with Mr. Floyd, very close in time before he's alleged to have ingested drugs. And again, it exposes him on that third-degree murder charge. If there were to be a future third-degree murder charge, and Mr. Hall was charged with basically being involved in this drug activity that had caused Mr. Floyd to pass away due to an overdose, him even being in that car incriminates him in terms of behaviors of Mr. Floyd, what he observed when he observed it. So, no, Your Honor, I would argue that it definitely would expose him to potential incrimination.
Well,
not to mention, Judge, that this is a car where drugs have been found twice.
Well, and the state has all that evidence. That's pretty clear. And I know we're not talking about, but that didn't incriminate him. The video of him sitting next to George Floyd does not incriminate him, or has not subjected him to criminal liability, at least yet. So
And
you're
I think
saying
that's
beyond
the,
that?
That's the key word, Judge, is yet.
Yeah.
Is yet. The
But
question
you
is,
think his observations of how George Floyd looked would incriminate him?
Absolutely.
I don't see how that would put him closer to criminal liability just with those observations.
because it then takes the onus off of the state in any future prosecutions to prove what demeanors, behaviors, attitudes Mr. Floyd was exhibiting should they decide to charge Mr. Hall with a crime. Now they've got his own testimony to use against him. That's the very definition of a Fifth Amendment privilege, Judge.
Well, if it incriminates.
Yes,
Just the fact that he testifies does not make it incriminating.
but his testimony would be used to incriminate him in a future prosecution.
Anyway, Mr. Frank, do you need to weigh in on this? I don't think you have a dog in the fight at this point.
Well, I do, Your Honor, and I would like to be heard briefly.
Sure.
Thank you, Your Honor. Our
You're
dog,
not going to represent his interests, are you?
I am not.
Okay,
Our dog in the fight is a fair trial for Mr. Chauvin,
of course.
and one trial. And what we can't have is an invocation of this privilege in front of the jury. And this questioning that the court is offering or suggesting creates a huge problem. And the reason why I cited the Caldwell case to the court is because this questioning would not exist in a vacuum. And we have to remember, too, that the standard is not just whether this evidence itself is inculpatory or implicates him, it's whether it creates a link. And I think that's partly what Ms.
Understood.
Cousins is referring to, is it now puts him in that vehicle, and it's testimony from he himself creating the part of that link. And as I said, it won't exist in a vacuum. There would be other questioning, and we would have the right to question him about his credibility and other aspects of that interaction then that would lead, unfortunately and potentially, to him invoking question by question in front of the jury.
But we regularly, in fact, did in this case, in excruciating detail, walk through motions in limine, limiting what questions could be asked of various witnesses based on rules of evidence. This is not based on rules of evidence, it's based on his Fifth Amendment rights and what could possibly incriminate him. But limitations, and you gotta admit, as Mr. Isaacman and I can tell you, the Caldwell case is a totally different situation. That was a man who wanted to testify despite being warned that everything he said would incriminate himself, and didn't care until he realized it might get him into more trouble than he thought. I think it's the complete opposite of this case.
It's an illustration, Your Honor, of how, despite that witness trying to tailor his evidence to meet a certain goal, it just couldn't be done. And it led to, and unfortunately in that case there wasn't a jury sitting there, but that invocation, that's where they ended up in that case. We can't have that when we're in front of a jury. And Mr. Hall would be faced with the question by question determination of what we're arguing about this morning. That's why sort of a blanket invocation is allowed, because the standard is rather broad.
What case law says that there is such a thing as a blanket invocation of Fifth Amendment
I
rights?
can't cite the court a case that has yet
Well,
used
and I'll
the
admit-
blanket invocation, but
And I'll admit, I don't think there's clear Minnesota case law on it, but I'm looking at Illinois, the Northern District of Illinois, Oregon, I think Hawaii as well. A couple of cases, just to take a look at Hillman versus City of Chicago, 918 F sub 2nd 775, which is the Northern District of Illinois. Oregon versus Rodriguez, 301 Oregon Appellate 404. Shackman, S-H-A-K-M-A-N, versus Democratic Organization of Cook County, which is 920 F sub 2nd 881. It's pretty clear from those cases, and granted they are not Minnesota, that the invocation of the Fifth Amendment right is on a question-by-question basis, and the legitimacy of that invocation is to be determined by the court, which makes sense. Otherwise, somebody who just didn't want to testify could say, I'm asserting my Fifth Amendment rights.
I agree with that concept, Your Honor. We cited the court a case where they talked about a voir dire process, and essentially this hearing is a substitute for that process, because we know from his counsel that he is going to invoke the Fifth Amendment about the very areas she discussed, and there just is no legitimate way. I mean, there isn't really any question that all of the matters that counsel identified and Mr. Nelson identified are tied intimately to his interactions with Mr. Floyd that day and in the previous weeks, and it ties him. So we're not facing a question like perhaps in those cases where they might just be invoking because they don't want to testify. Here there is a legitimate link in the chain from what he's going to be asked about, and quite a few potential crimes, not just the third-degree murder, obviously being the most important. I mean, we even know, we've talked about the sense of, opposing counsel has suggested almost an alternative perpetrator. In that sense, with the third-degree murder, but there's also drug charges, counterfeiting, false information. And I don't know how we put on Mr. Hall to testify and ask him one question and then let him leave without having the ability to pursue, as we normally would in a trial, the credibility and the foundation for that testimony in light of all we know. So I think that this case doesn't raise the kinds of questions that maybe are being brought up in the cases the court cited. I'm sorry, I can't speak to them personally right now, but here there's no question that the singular questions the court is inquiring about are intimately linked to George Floyd and the activities of that day, all the other areas that
Well, I think if you look at the case law, it's much closer to incriminating behavior like the Shackman case. It's really clear that I would have not ruled the way they did. I would have said that was a proper invocation. And they're like, no, it's not a problem.
Well, that's Illinois.
Yeah, let's do this step by step. I appreciate your argument, and I think I know where we're kind of heading with that. This is what I'm going to propose. We're not done today with this. I think we have pretty much established, or based on what Mr. Nelson has said, there's really a very small, narrow topic that might be permissible. So what I'm going to do is I'm going to ask Mr. Nelson essentially to draft in written question form with the expected answer based on whatever statements were made on what that would be. That way, Mr. Hall can meet with his lawyers and talk about would he be willing to answer those. Then we can have another hearing outside the hearing of the jury where we walk through and see if he would, number one, if I, based on my review of the examination, believe that it is a proper invocation of Fifth Amendment rights to that or not, question by question basis. And if I say it's not a proper invocation, is Mr. Hall willing to answer? Despite your ruling, Judge, he's still not going to? Well, he is subject to contempt then. But I think we get too far ahead. Let's say, what are the questions we're going to ask? Let's walk through outside the hearing of the jury whether or not I would allow it and find that it's not incriminating. And then based on that, Mr. Hall can meet with his lawyers. So I'm talking by Thursday. I'd like that list. The state can do any indication of cross. Same thing. I'm guessing what you would want to cross Mr. Hall on as far as his credibility and all that, well, it's pretty much up to you, Mr. Frank, but I think that since it might widen the net, so to speak, some of yours might clearly get him into Fifth Amendment issues. But I think we need to, if Mr. Nelson can get you that, you can write up your own list of questions, and let's do it outside the hearing of the jury. And he has time to talk to his attorneys before we put him on the stand cold, and he has to confer with them one by one. So, and it's a limited, I'm only allowed for that, limited, and this isn't a final ruling, this is the only part that I think is possibly not subject to a Fifth Amendment claim. Tell me what you want to ask. We'll run it by outside the hearing of the jury on a question by question basis. The court will make a determination, and then counsel can follow up with Mr. Hall, and based on the court's ruling, are you going to testify? And we go from there. So I don't want this to be the last and try and push through a ruling when we need to tread carefully, obviously. Fifth Amendment right is a broad one, and I agree. The link, you have to worry about links to possible prosecution, but at the same time, if everything's linked, then it's a blanket prohibition, and that is not the case law. So with that, everybody's got their homework assignments. Let's go with that. All right?
Very well. Thank you, Ron.
But for now, do not waste your time on all the other stuff. It's that narrow, limited area that we're going to talk about. Okay?
Thank you.
It's 5 to 9. Let's see if we'll probably start up at 9:15 with the jury. All right, we're in recess. Thank you, Mr. Hall.
Thank you, Judge.
If Mr. Elson can get us something Thursday, I'd like everybody else to maybe.
All right, let's fast forward to.
EddieBlockFilms. EddieBlockFilms. You watching
EddieBlockFilms, EddieBlockFilms
You
Show,
watching?
EddieBlockFilms, EddieBlockFilms Show, EddieBlockFilms,
watching?
EddieBlockFilms, EddieBlockFilms Show, EddieBlock.
Stating your full name, first of all, if you
Yeah, we watching Eddie, getting facts ready, keeping all the cameras steady, audio ready, so unlock, yep, and unload, Patriots prepare for.
First of all, if you feel comfortable doing so, we'd appreciate if you could remove your mask so you'd be heard more clearly. And then begin by stating your full name, spelling each of your names.
My name is Kerr Yang. First name is spelled K-E-R, last name is spelled Y-A-N-G.
Mr. Slisher.
Thank you, Your Honor. Good morning.
Good morning, sir.
How are you employed?
I am employed with the City of Minneapolis Police Department.
How long have you been employed by the City of Minneapolis?
I have been with the department for approximately 24 years.
And what's your current position with Minneapolis?
My current position is I am the Crisis Intervention Training Coordinator for the department.
And your current rank?
I hold the rank of sergeant.
First, I'd like you to tell the jury a little bit about yourself. How old are you, sir?
I'll be 50 this year.
Okay. And you indicated you've been employed by MPD for 24 years?
Approximately 24 years, yes.
Could you please share with the jury your educational background?
I received my bachelor in psychology and criminal justice. I received my master's degree in counseling psychology and my doctorate in general psychology.
When did you complete your doctorate?
I completed that back in 2014.
And when you started, after you started with MPD, did you go through the academy?
Yes, I did.
Describe that experience. What year did you start?
I started the academy as a cadet in September of 1996. I had to take some additional college courses because of the cadet program, and then from the cadet program, I went through the academy as a recruit.
After you completed the coursework at the academy, did you enter the field training program?
Yes, I did.
And how long were you in that program?
I believe it was approximately 6 months, 5 or 6 months. It's been a long time ago, so.
After you completed your field training, what was your first assignment?
I was assigned to, if my memory served me properly, I believe I was assigned to downtown precinct after I finished my field training.
As a patrol officer?
Yes, as a patrol officer.
And how long did you serve as a patrol officer before being promoted to sergeant?
I was a patrol officer for, I would say, if not including specialty unit 2, I would say a little bit over 10 years.
Would you please describe for the jury some of the precincts to which you were assigned in your assignments before promoting to sergeant?
I was assigned to downtown precinct. I was also assigned to the Police Activity League. I was also assigned to Housing Patrol, School Patrol, and 5th Precinct before I came to actually 5th Precinct, and when I got promoted, I was assigned to 4th Precinct during my supervisor orientation. I went to robbery for my supervisory orientation, and then I was assigned to downtown as a supervisor before I became the Crisis Intervention Training Coordinator for the training unit.
Now, as a patrol officer, have you ever been in a situation where it's been necessary for you to use force?
Yes.
Have you ever arrested a suspect?
Yes.
Have you ever arrested a suspect who was reluctant to be arrested?
Yes.
You've had to handcuff people who are struggling?
Yes.
And now you're the crisis training coordinator. Where are you assigned as the crisis training coordinator?
I am currently assigned to the training unit.
Where's that located?
It's located on the north side at what we call the Special Operations Center at 4119 DuPont Avenue North.
Can you please describe your role as the crisis training coordinator?
As the crisis training coordinator, I am responsible for collaborating and coordinating with mental health professionals and community members and civilians to come and teach our officers about crisis and crisis de-escalation. And at time, I've also trained our officers too.
What do you mean by crisis?
Crisis could be any event, situation that is beyond a person's coping mechanism. And during that, when it's beyond their control, sometimes they don't know what to do. And we train them to assist a person to bring them back down to their pre-crisis level.
Could you please share with the jury some examples of types of crises?
Crisis could be mental health, mental illness related, or it could be situational. It could be that somebody got into a car crash, for example, and they're just so affected by that they don't know what to do, and that could be a crisis. So that could be an example of a crisis.
Can intoxication be a crisis?
Yes, intoxication can be a crisis too, yes.
Through drugs or alcohol?
Yes.
Certain types of anxiety could be a crisis?
Yes.
Does the Minneapolis Police Department have a policy pertaining to persons in crisis?
Yes, it does.
And at a high level, can you explain what that policy requires?
That policy requires that when it's safe and feasible, that we shall de-escalate.
Does the Minneapolis Police Department, I'm assuming as the crisis training coordinator, you're aware of any training or tools that it provides law enforcement officers to abide by this policy?
Yes.
Does that include training officers to recognize when persons may be in crisis?
Yes.
Some of the signs of crisis and types of crisis?
Yes.
And there is a specific crisis intervention training course that the Minneapolis Police Department sponsors or puts on down at the training center. Is that right?
That is correct, yes.
And in your role as coordinator, you bring the instructors in for that.
That is correct.
Have you been through the course itself?
I have been through the course, yes, and I have sat through some of the courses too, yes.
Right. Now, Exhibit 203, which we won't publish at this time, contains some training records, and those training records indicate that crisis intervention training was offered within 2016 and also 2018. And I'd like to talk to you about the larger block, the 2016 block. Now, first I have to ask you, do you recognize the name Derek Chauvin?
Yes.
How do you recognize it?
I recognize the name Derek Chauvin through training.
Okay. You're familiar with this person?
No.
Would you recognize him if you saw him?
Yes.
All right. Do you see him in the courtroom today?
He has a mask on. I'm assuming that's him.
All right. May the record reflect that the witness has identified the defendant.
Record also reflect.
Exhibit 203, the training records indicate that in 2016, the defendant participated in a lengthier course, approximately a 40-hour course in crisis intervention training. Are you familiar with that type of course, the 40-hour crisis intervention training course?
Yes.
And is that a course that you've personally participated in as a student?
That course was delivered to the department, to the officers by Minnesota CIT Officers Associations.
And can you, just in general terms, explain what that course covers?
That course covers individual in crisis, symptoms, and de-escalation strategies that may be used for individual in crisis. So it's a scenario-based training.
What do you mean by that?
The trainer, Minnesota CIT Officers Association, brings in professional actors to come in and to conduct crisis scenarios where they're in a state of crisis, and then our officer has to use de-escalating strategies to bring them down to pre-crisis level or to help them out.
And so the officers are given an opportunity to practice recognizing what may be signs of persons in crisis and respond appropriately?
Yes.
Right. I'd like to talk to you about a related concept. You're familiar with the critical decision-making model?
Yes, I do.
How are you familiar with that model?
I attended the critical decision-making model introduced to us by the police executive research forums. I, along with some of my colleagues, we attended a training session that was conducted by a representative from PERF, or the Police Executive Research Forums, and we adapted that model to MPD's use to guide our officers in their decision-making process.
And does the critical decision-making model, is there an application to crisis intervention?
Yes, it does.
Also an application to use of force?
Yes.
And sometimes those decisions will have to be made contemporaneously, is that right?
Yes.
At this time, I'd like to publish Exhibit 276, the critical decision-making model. You recognize this document?
Yes, sir.
And this is the critical decision-making model with which you're familiar?
Yes, sir.
Could you please explain, based on your familiarity with this graphic, the middle circle?
The middle circle, what you see in the middle circle are voice, neutrality, respect, and trust. Those are the pillars of procedural justice that was introduced to the department.
What is procedural justice?
Procedural justice basically is the legitimacy in our action. What we do are our actions legitimate, and that is what procedural justice is about, is legitimacy.
And the training center also offers courses in procedural justice as well, is that right?
That is correct, yes.
This critical decision-making model is adapted in part from those materials, the procedural justice materials.
That is correct, yes.
Okay. Now, going back to the outer part of the circle, the first step of information gathering, and you see that it goes kind of a wheel that's supposed to represent critical decision-making or thinking, is that right?
That is correct.
Would you please, we've heard a little bit about this critical thinking decision-making model already, but I'd like you to discuss how this works in the context of crisis intervention, starting with the first block.
Starting is information gathering. We believe that this model has application not only for crisis, but especially for crisis. That is why it is part of our crisis curriculum. And the first circle, what you see there is information gathering. And information gathering is very crucial to what tactics or what decisions we're going to make. And information gathering could be based on dispatch, or it could be based on the own officer's observation.
Observations of what?
Observation of the scene, observation of the person, could be observation of the environment that's going on.
And some of these observations, for example, could just be physical observations, right? The officer could look at the person and make some sort of an assessment as to whether or not there's a behavioral crisis.
Yes.
Listening, is that also important?
Listening is important, yes.
Any other information that an officer would generally assess or take in when considering whether a person is in crisis?
Even listening is key. Other observation, even touch, for example. If you observe hands is on the person, you can sometimes sense tensing up, and you can tell that maybe the person's in crisis or not. So
then going to the next step, taking that information and potentially assessing it, what's the threat risk assessment block?
Risk is the possibility that something bad or dangerous may happen, and threat, in a sense, is the danger, and whether that danger is going to cause harm or not.
Now, with risk, you say it's the potential, right? So it doesn't necessarily mean that the person is being threatened or themselves is threatened. Is that right?
That is correct, yes, sir.
It's just the mere possibility. And many people could present some sort of a risk. Everybody presents some sort of a risk, right?
Yes.
And it's up to the officer in the information gathering to determine whether that risk is small, large, or elevates to a threat.
Sustained.
And how does the, apologize, Your Honor, how does the officer then assess whether or not a risk is small, large, or could develop into a threat?
That is up to the officers and the totality of circumstances and information they have at that time.
The next step then, after the threat or risk assessment, authority to act, could you please describe how that step is taken in the context of crisis intervention?
The authority to act is based on our policy and also based on state statutes and case law too for individual in crisis. And those are some of the authority that we have in handling people in crisis.
Some of those policies and the authority could include the use of force policy,
Yes.
the de-escalation policy,
Yes.
and the crisis intervention policy.
Yes, sir.
The next step, then, goals and actions. Please describe the thinking model in terms of crisis intervention regarding goals and actions.
Goals in action is also contingency on based on the information. Really, the ultimate goal in action of somebody in a crisis is to see if that person needs help and what kind of help. Does that person need to go to the hospital, or does the person can be turned over to somebody that has the authority to watch over that person? So it's really to go for somebody in crisis is determined to see if that person needs help.
And then the next block in terms of crisis intervention, review and reassess. Could you please describe how that works in this scenario?
Review and reassess is as information becomes available. We continuously review and reassess the situation to see if our technique on de-escalation or other technique is working. If it's not working, then we adjust our technique and our strategies.
Could you also then go backwards and adjust your goals and actions?
Yes, you can.
So, for example, if initially the goal is to arrest someone, after taking in information, if you determine the person needed medical attention, could you act on that?
Yes.
And then what would the action be if the person was in need of medical attention?
That would be the immediate goal for us. If somebody's in need of medical attention, then we give them medical attention.
Okay. And then that would also relate to the authority to act, is that right?
Yes.
Looking at the policy, and there's a duty to provide medical attention in the policy, right?
Yes.
Now, how is this critical decision-making model imparted to Minneapolis police officers in the training program?
We believe in the application of these critical decision-making models. So I introduced this model with approval, of course, to the department in 2018.
And, you've been in the situation where you've had to use force before. You were in the field for a long time. Do you have an assessment as to whether or not this model is useful in the field?
I believe it's useful. That is why we introduced this model and introduced it to the officers.
And is it practical?
It is practical. Yeah, I believe it is practical.
And can you explain how so? I mean, some of these situations involving police officers occur fairly quickly. Is that right?
That is true.
Is it possible for a police officer to use this critical thinking model in the field when events are unfolding quickly?
It is possible. To rehearse and reusing this model, it would almost be like it could be almost like memory. And when we talk about fast evolving situations, I know that they do exist, they do happen, but a lot of the time we converse of that is that a lot of the time we have the time to slow things down and reevaluate, reassess, and go through this model.
Do you provide this training because you believe it works?
I will provide this training because I believe it works, yes.
Thank you. I have no further questions.
Mr. Nelson.
Good morning, sir.
Good morning, sir.
Thank you for being here with us today. I have a few follow-up questions. So your role with the Minneapolis Police Department is currently training officers involved in the crisis intervention techniques?
That's correct, sir, yes.
As well as the critical decision-making model, correct?
That's correct, sir.
And you assisted the Minneapolis Police Department in developing its policies and procedures surrounding both the crisis intervention technique as well as critical decision-making policies, right?
Yes, sir.
Right. You said you introduced these policies with the approval from the chief or the higher-ups, right?
It has to be approved before we can deliver this training, yes.
Right. And these trainings then ultimately helped form some policies of the Minneapolis Police Department.
Yes, but not the critical decision-making model. It's not in the policy.
Right. But the crisis intervention technique is in the policy.
Crisis intervention is in the policy, yes.
Okay. So, and you have a long career as a police officer, both in the field and also in the training and investigation units. And so you have your own personal experiences in dealing with people out on the street, right?
That's correct, yes, sir.
Now, are there situations in your own experience where you've had to use force on someone and other people observing the use of force don't like what you're doing?
Yes, sir.
Okay. And in fact, I believe you would describe sometimes that the public doesn't understand that police actions can look really bad.
That's correct, sir, yes.
Right. But they still may be lawful even if they look bad, right?
Yes, sir.
And part of the whole goal of the crisis intervention technique or policies is to not only deal with the suspect, but also other people who may be watching, correct?
That's correct, yes, sir.
And so in situations where citizens or bystanders start to congregate and watch what police are doing, you would agree that that could potentially become a crisis for those observers.
Potentially, yes.
And you train officers in how to deal with those situations, right?
That's correct, yes, sir.
When we look at the critical decision-making model, not policy, but when we look at the critical decision-making model, that is what you would describe as a rapid, very dynamic model, right?
Yes, sir.
It's not just focusing on one particular thing, it's assessing many, many things that are happening in the context of an arrest, right?
Yes, sir.
And some of those things could be the interactions that you're having with citizen observers, right?
Yes.
And the training that you provide, there are materials that the department maintains, correct?
That's correct.
So I'm going to ask the court to just display to the witness. Switch this here. What has been marked as Exhibit 122. Do you recognize this to be training materials prepared by the Minneapolis Police Department Crisis Intervention Team?
Yes, sir.
All right. And so I'm going to just go. So I'm going to have you just look at this. This is the material and the training materials that the crisis intervention team present to the officers in this 40-hour training, right?
No, sir.
This is the training that you received?
This is the training that I created. It wasn't delivered to Chauvin or the other officer.
Okay, so this is something that you created to train Minneapolis police officers?
Yes.
All right. But this is a more recent model than the 2018 model?
This is a program that we created really to target the recruit in the cadet academies.
Okay.
Yeah. So this is separate from what Chauvin and the other officers went through.
Okay. But some of the information is generally applicable to all police officers who are trained in crisis intervention as well as de-escalation, right?
Yes, sir.
And officers are trained to look for potential signs of aggression from suspects or crowd observers, right?
Yes, sir.
And what are some of the potential signs of aggression that officers are trained to watch for?
Based on this document that you sent here, it could be standing tall, red in the face, raised voice, rapid breathing, muscle tensing, agitations, pacing, prolonged eye contact, exaggerated gesture.
So an officer who is making an arrest of a suspect and there's bystanders watching and growing in their intensity, these are the types of behaviors that officers are specifically trained to watch for from either the suspect or observers, right?
Yes.
Sidebar?
And the sidebar.
Yang as a
Rephrase.
Thank you. Mr. Yang, as a part of, or excuse me, Sergeant Yang, as a part of your role in the Minneapolis Police Department, do you train both cadets, recruits, as well as veteran officers?
Yes, I do.
Okay. And can you describe the difference between the training that a cadet would receive versus a veteran officer?
Something like this will be given to the recruits and officers that have gone through the Minnesota CIT Officers Association's training on crisis de-escalation. We will give them a progression training. We will introduce other topics like autism to them and go through different type of topic that is part of crisis training. So it's a little bit different. It's different from what the recruits and the regular officer will get.
Now, the information that is presented to recruits versus veteran officers, is it generally the same type, broad categories of information?
It's possible the same, yeah, similar. We want to be consistent, so it's similar, yes.
Right. And so the information that a veteran officer would receive in a 40-hour training would be inclusive of what to look for in terms of crisis, would it not?
Yes.
Right. You would train officers on the policy about crisis intervention, correct?
Yes.
You would train them about what to look for when a person is in crisis, right?
Yes. Are you talking about recruit training or the veteran officer?
Veteran officer.
The veteran officers, are you referring to the 40-hour training? Or
Yes.
40 hours training, I have nothing to do with the 40-hour training for the veteran officer. That's Minnesota CIT Officers Associations.
Okay. So you don't know any information that the veteran officers would receive?
I do know some of it, but not the entire curriculum.
Okay. You've trained veteran officers yourself?
I do, but not in the 40-hour week.
Understood. But in the refresher type courses?
In the refresher type course, yes.
Right. And in the refresher type courses, do you discuss with officers the policy of crisis intervention?
Yes.
Do you discuss with officers the signs to look for, both in terms of suspects as well as individuals observing?
Especially the suspects.
Especially the suspects.
Yes.
But ultimately, you would agree that that training also includes the critical decision-making model, right?
Yes.
And the critical decision-making model is not limited to or focused on simply the suspect, correct?
He's back onto a topic where he can lead now.
Correct?
I'm sorry?
I was just answering the objection. It's overruled, so you can answer.
Okay. Will you repeat that, sir?
Sure. I have to remember my question. The critical decision-making policy that you train veteran officers on would be inclusive of people other than just the suspect. Is that correct?
There is no policy on the critical decision-making model, only on the crisis policy.
Okay. The critical decision-making model, I keep calling it a policy, that's just my fault, but the critical decision-making model is not limited to interpreting or responding to the suspect exclusively, is it?
That's correct.
An officer is trained in the critical decision-making model to go out and review the entirety of the situation, the totality of the circumstances, correct?
That's correct, sir.
And the totality of the circumstances is more than just how you interact with the subject with whom you are arresting, right?
That's correct.
That would include citizen bystanders, right?
That's correct.
What to do when a citizen bystander starts filming you.
That's correct, yes, sir.
How to try to interpret whether citizens' pose a threat or a risk, right?
Right.
How to you would consider your own interactions also with the suspect themselves, correct?
That's correct.
And you describe this critical decision-making model as being a very dynamic, ever-changing thing based upon information that comes to the officer in real time, right?
That's correct. Yes, sir.
And so an officer may consider, who has used force, may move backwards in the policy, but may have to jump somewhere else in the policy because new information comes, or the model.
Yes, sir.
And so it is a constantly evolving process where an officer is entrusted to make decisions based on all of the information that he or she perceives, correct?
That's correct, sir. Yes, sir.
Right. And that also would include training, right? Their training.
Yes, sir.
And other things that may not be apparent to a citizen.
Yes, sir.
Right. Tactical decision making, for example.
Yes, sir.
Knowing that medical help was on the way, right?
Yes, sir.
Making decisions about officer safety, right?
Yes, sir.
So all of these, it's not just one small thing that you're focused only on the subject that you're arresting. You're taking in a lot of information and processing it all kind of simultaneously through this critical decision-making model. Agreed?
That's great. Yes, sir.
All right. And so in terms of, and I'll take this down for now, but in terms of the information that you advise or talk to officers, veteran officers about, are how to recognize the signs of someone in crisis, right?
Yes, sir.
And the Minneapolis Police Department policy on crisis intervention has a pretty specific definition of what constitutes a crisis, right?
Yes, sir.
It's not limited to someone who may have a mental health problem, right?
Yes, sir.
It could include people who are using controlled substances.
Yes, sir.
It could include people who are simply experiencing some event that is overwhelming them, right?
Yes, sir.
And that may be losing a job or getting a divorce, but it could be what that person is observing at the time. Agreed?
Yes, sir.
And so the crisis intervention policy actually defines crisis as having a trajectory, correct?
Yes, sir.
And that trajectory can increase in its severity over time.
Yes, sir.
And that's why it becomes important for an officer to create time and distance, right?
Yes, sir.
And creating time and distance for an officer is an important part of the de-escalation process, is it not?
Yes, sir.
And would you agree that you train police officers that as that intensity of crisis increases, the risk or threat to the officer grows greater?
I don't believe I train a specific like that because as the intensity, my training is that as the intensity increases and you have the distance and you, like you said, the time, you try to bring it down, not increase the intensity of it.
What I'm talking about is not the officer trying to increase the intensity of it. My question is this: as a person is in crisis and the intensity of their own personal crisis grows, you train officers that as they kind of get more intense, the risk to the officer or others is greater.
Yes, sir.
And in fact, officers are trained to respond to that in a variety of ways, right?
Yes, sir.
And some of the techniques that the Minneapolis Police Department trains both veterans and recruits would be to have a confidence about them, right?
Confidence about them?
Right.
Yes, sir.
an officer should try to appear confident in his or her actions.
Yes, sir.
They should also try to stay calm, right?
Yes, sir.
They should try to maintain space, right?
Yes.
They should speak slowly and softly.
Yes, sir.
They should avoid staring or eye contact.
Yes, sir.
And ultimately, when a police officer is dealing with any situation, they could be dealing with any number of people who are in crisis, right?
Yes, sir.
Right? The subject, the arrestee, may be in crisis, right?
Yes, sir.
People who are watching may be in crisis.
Yes, sir.
Another officer could be in crisis,
Yes, sir.
right? And an officer has to take all of that in and do this assessment and make a determination as to what his or her next steps would be, right?
Yes, sir.
And the observations of the officer in that situation, I think you described on direct examination, you described that an officer will also take into and apply to the critical decision-making model his or her own sensory perception.
Yes, sir.
So the touch of feeling a suspect be tense, right?
Yes, sir.
Or loose, right?
Yes, sir.
What they may hear comes into play.
Yes, sir.
So if they hear people threatening them or potentially threatening violence, that goes into that critical decision-making model as well, right?
Yes, sir.
And oftentimes, the scene of an arrested individual is very tense, right?
Yes, sir.
I have no further questions.
Any redirect?
Yes, sir.
If we could publish Exhibit 276 again, please. Thank you. So I'm displaying again the critical decision-making model that you've been testifying about. And the thrust of your direct testimony was using this in terms of assessing a person in crisis for the purpose of determining whether or not they needed medical intervention. Is that right?
Yes, sir.
Now, in discussing this, and I guess relating it to some of the broader force concepts that defense counsel was questioning about, again, all of these things must be taken into account when deciding the next step. Is that right?
Yes, sir.
And the officer always has to keep in mind their authority to act. That's one of the parts of the model. Is that right?
Yes, sir.
Now, defense counsel asked you if the officer should just focus on one small thing. And I would like you to make some sort of comment on differentiating between a small thing and a big thing, because you would agree that something that is a big thing would probably be more important than a small thing, right?
It depends on what the big thing is and what the small thing is.
Well, for example, if we're looking at assessing somebody's medical condition, right, for the purpose of rendering emergency aid, would that be a big thing or a small thing?
That would be a big thing.
If then that is contrasted with, say, a 17-year-old filming you with a camera, would that be a big thing, the filming, or a small thing?
The filming would be a small thing.
And so then if you're taking all of the situations, all the circumstances into account, you have a big thing and you have a small thing, you're again looking at your authority to act, and that's policy, right?
Yes, sir.
And policy would include the policy governing the use of force and that it must be reasonable, correct?
Yes, sir.
And it would also include for authority to act, the duty to render medical aid. Is that right?
Yes, sir.
As the policy is written, correct?
Yes, sir.
Which includes not only contacting the ambulance, but performing emergency aid like chest compressions or CPR.
Yes, sir.
Nothing further.
Anything further? Briefly, please.
Sergeant Yang, in terms of the critical decision-making model, again, you're analyzing all of these things, medical aid, threats from citizens or observers, whether people are recording, what you're seeing, what you're feeling. It all is premised on whether it is safe and feasible to do something, correct?
Yes, sir.
Nothing further.
Anything else?
No, Your Honor.
All right, thank you, Sergeant. You are excused.
Thank you, Your Honor.
And is that your water, sir? Or is it? Oh, okay, thanks. Thanks. All right, next witness, please.
Thank you, Your Honor. Your Honor, the state calls Johnny Mercel.
Raise your right hand. You swear or affirm under penalty of perjury that the testimony you're about to give will be the truth and nothing but the truth?
Yes, Your Honor.
Have a seat, please.
Thank you.
Yeah.
Thank you.
You anticipate what I was going to ask you to do. If we could have you state your full name, spell each of your names.
Johnny Mercil, Johnnny. Mercil is Mercil.
Mr. Slisher.
Thank you, Your Honor. Sir, how are you employed?
With the City of Minneapolis Police Department.
Right? And what do you do for the city of Minneapolis?
I'm currently on medical leave, but I'm a lieutenant with the Minneapolis Police Department.
How long have you been with MPD?
Since 1996.
I'd like you to tell the jury a little bit about yourself first. Could you share your educational background?
Yes, sir. I got a 4-year degree from the University of North Dakota in criminal justice studies.
What year?
I graduated in 95.
And after you graduated from the university, did you get a job in law enforcement right away, or did you go elsewhere?
No, sir. I got hired from the Minneapolis Police Department in 1996 and joined the Minneapolis Police Academy.
Describe your academy experience.
I was a cadet, so we did a combination of the police academy along with college courses to qualify for the Minnesota post test.
Did you take and pass the post test? Your
Yes, sir.
Licensed peace officer?
A little bit so we don't talk over each other.
Yes, Your Honor.
All right, thank you.
Yes, sir.
All right. After you completed your coursework with the academy, did you go into a field training program?
Yes, sir.
How long were you in that program?
I believe it was about 4 months at that time.
Okay. And then you received your first assignment as a police officer, is that right?
Yes, sir.
Can you please tell the jury what your first assignment was? Where were you and what were your duties?
Yes, I was a patrol officer assigned to the 3rd Precinct, which is southeast Minneapolis. And duties are patrolling the streets, answering 911 calls.
Okay. Now, how long did you serve as a patrol officer in the 3rd Precinct?
Initially for a couple of years, and then I went to the community response team, which is a plainclothes unit.
What is it's also referred the community response team? I've heard it called the CRT.
Yes, sir. CERT team.
CERT team. What does that do?
They respond to the local community's concerns about crime, prostitution, drug dealing, gang activity.
How long were you with the CERT team?
I did that for about 3 years.
And then what was your assignment afterwards?
From there, I went to the Mounted Patrol unit, and that was technically downtown unit at the time.
What does the Mounted Patrol unit do?
We patrol on horseback, mainly crowd control. For busy times in Minneapolis, we focused on bar close in downtown Minneapolis.
Yeah, how long did you do that?
Full time for about 1.5 years, and then I went to patrol in downtown Middle Watch, the precinct.
Okay. How long were you in the downtown Middle Watch assignment?
I was on downtown middle watch until 2006, and then I got promoted to sergeant.
In order to be promoted for sergeant, did you take an exam and pass it?
Yes, sir. It's a civil service exam along with an assessment center.
And after you were selected as sergeant, you received your first assignment?
Yes, sir.
What was that?
I went to the robbery unit in downtown here at City Hall. And then from there, I went to the juvenile unit. And then I eventually ended up back downtown on patrol as a supervisor.
Okay. And how long did that take? What year are we up to now?
Oh, I think we're at about 2007, 2008.
Okay. And after that?
I was there for a couple of years. I ended up going back to Mounted Patrol full-time as a sergeant in charge of the unit. That went through 2009. I went back to the street for about a year and a half, and then I went to the Minneapolis Police Department's gang enforcement team as a sergeant.
Okay.
And then we, from there, I investigated gang crimes, gun crimes. And then after that assignment, I ended up on the north side on patrol for about a year and a half, and then I went back downtown as a sergeant on the community response team, the CERT team downtown. And then in 2017, I took the exam for lieutenant and passed and was a lieutenant in 2017.
And where were you assigned then as a lieutenant?
After I got promoted, I was transferred to the training division in charge of use of force.
I'd like you to talk to the jury a little bit about your own background in the use of force. You're familiar with the Minneapolis Police Departmental policy regarding the use of force?
Yes, sir. I trained for several years for that.
That was a part of your academy training?
Partially. You get to be familiar with the use of force through the academy.
And then after you left the academy, did you have to take refresher courses, which would have included use of force training every year?
Yes, sir.
In order to maintain your post license?
That's correct, sir.
Have you had training beyond that, beyond what was presented at the academy and your yearly certification?
Yes, sir.
Could you please describe it?
Yes, I became a part-time use of force instructor in about 2010, and I maintained that part-time status as a use of force instructor up until I was promoted to lieutenant, where I went to the training unit full-time.
What did you have to do to become qualified to be a use of force instructor?
Went through different courses designed to train us up on use of force. I also started training Brazilian Jiu-Jitsu for the department as part of our ground defense initiative. Several other classes and different academies I went through too.
And I'd like to maybe qualify a few terms, if we may. We talk about use of force and use of force training. We also hear the term defensive tactics. Can you differentiate between the two?
Well, I think they're interchangeable. I think use of force is probably the more appropriate term, but I think defensive tactics has been more of a term that's been used longer, so people tend to refer to use of force instructors as defensive tactic instructors.
Would a defensive tactics, in terms of defensive tactics instruction, include more hands-on type instruction? You'd mentioned Brazilian Jiu-Jitsu, for example.
Yes, sir.
Right. Were you interested in Brazilian Jiu-Jitsu before becoming a police officer, or how did that develop?
No, sir. I was in martial arts through college, and then I got interested in it from some of the other use of force instructors, kind of recruited me to do that. And really fell in love with the art form and really what its implications and uses are for law enforcement specifically.
Would you please just provide a very high-level overview of what Brazilian Jiu-Jitsu is and some of its basic principles?
Yes, sir. It's a form of martial art that really focuses on leverage and body control, de-emphasizes strikes. In a true Brazilian Jiu-Jitsu, there aren't strikes. There's no punching or kicking. It's using your body weight, kind of like wrestling, and joint lock, manipulation, neck restraints, things that, pain compliance as well as physical body control to get people to comply.
So you use that phrase, pain compliance. What is that?
Pain compliance is using a technique that causes the person you're using it against to have pain so they comply to your whatever it is you're asking them to do.
So if we were to use an example, maybe from childhood, you're familiar with the game Mercy,
Yes, sir.
right? Where you lock fingers and twist down and then somebody has to submit. Is it similar to that?
Yes, sir.
All right. Although Brazilian Jiu-Jitsu is not the only defensive tactic that officers at MPD are trained on, is it?
No, sir.
It's just one of a variety of different tools that can be employed to deploy force. Is that right?
That's correct.
For the purpose of enforcing the law, correct?
That's correct.
Then, as a use of force instructor, after you became certified, did you have to become knowledgeable in all the relevant departmental policies and procedures regarding the use of force, the 5-300 series?
Yes, sir.
As well as state law governing the use of force, which is largely integrated into Minneapolis departmental policy. Is that right?
Yes, sir.
And you indicated that you were the lieutenant. You were a lieutenant over in the training center. Is that right?
Training division, sir.
Training division. And please describe your role then as a lieutenant in the training division.
Yes, sir. I was in charge of use of force. I was also in charge of our patrol operations section of training, as well as the police range. And I was in charge of all of our continuing education to make sure that our officers are fulfilling their post mandates to maintain their license to be a police officer.
And as part of that, to make sure that you're properly reporting to the post board, you keep records, sign-in sheets, and whatnot of particular officers having completed training. Is that right?
That's correct.
And those training hours are collected and reported into the Workforce Director Program?
Yes, sir.
Right, so you have an accurate record of who's been trained in what. Is that right?
Yes, sir.
And is it when you're the lieutenant of the training division with use of force, are you coordinating both pre-service and in-service training?
Yes, sir. The pre-service side would be use of force, the range, and patrol operations. The in-service side is what we consider to be the post mandates that we have to keep up with. That's the post-service side, in service.
And as a lieutenant, obviously, you're in charge of, you're in a position of rank over the sergeants. Is that right?
That's correct.
And those are usually the level. The trainers would largely be at the sergeant level. Is that right?
Mainly officers with some sergeants overseeing.
As the lieutenant and the person in charge of this training, are you familiar with the curriculum that is imparted upon both pre-service and in-service trainees?
Yes, sir.
You help develop the curriculum.
Yes, sir.
And you approve the curriculum.
Yes, sir.
The curriculum could include, does include just a general booklet that's put together by the defensive tactics instructors. Is that right?
Yes, sir.
And that booklet contains the general concepts for use of force that are imparted on pre-service trainees and in-service trainees. Is that right?
That's correct.
If I could show Exhibit 126 just to the witness. All right, I'm showing you what's been marked for identification as Exhibit 126. It's labeled Minneapolis Police Department Use of Force Manual Academics and Techniques, produced by the MPD Defensive Tactics Team. Are you familiar with this document and its predecessor documents?
Yes, sir.
Does this document contain sort of the general curriculum and knowledge that's imparted upon MPD pre-service and in-service trainees?
Yes, sir.
Offer Exhibit 126.
126 is received.
And we won't publish that at this point. And do you also participate in and approve various classroom PowerPoint training sessions that are imparted upon both pre-service and in-service trainees?
Yes, sir.
And at this time, just to the witness, I would like to show what's been marked for identification as Exhibit 119. Exhibit 119 is a slide deck that's labeled 2018 Defensive Tactics in Service. Is that right?
Yes, sir.
If you could show the witness the second page. And And do you see your name on the slide deck listed at the top of the instructors?
Yes, sir.
Are you familiar with the contents of this particular PowerPoint presentation or slide deck?
Yes, sir.
Did you help create it?
Yes, sir.
And you approved its use during the training, is that right?
That's correct.
And it's listed as fall of 2018, so this is what would have been provided for in-service training, so experienced performing officers during this 2018 session, correct?
That's correct.
And is the training that's provided, you have quite a few Minneapolis police officers who have to go through the training, right?
Yes, sir.
So they're not all taking it at the same time.
That's correct.
But if someone has completed the fall 2018 in-service defensive tactics training, does that mean that they saw this slide deck?
Yes, sir.
I'll offer Exhibit 119.
No objections.
119 is received.
Then we talked about training records as well and sign-in sheets, and so I'd like to show the witness Exhibit 124. Exhibit 124 is labeled 2018 Annual In-Service Training Program Group B. Is that right?
Yes, sir.
And I see your name at the top as one of the instructors. Is that right?
That's correct.
This is a sign-in sheet that would show different officers who would sign in having taken the training.
That's correct.
Turn to page 2. Do you see the name Derek Chauvin on this training roster?
Yes, sir.
Are you familiar with that name, Derek Chauvin?
Yes, sir.
Chauvin, I'm sorry, Derek Chauvin. Do you would you recognize Mr. Chauvin if you saw him in the courtroom today?
Yes, sir.
Do you see him today?
I do, sir.
Would you please point to him and describe what he's wearing?
Yes, sir. He's got a dark blue tie, light blue shirt, and a gray jacket.
May the record reflect the witness has identified the defendant.
It will.
Go back to page 1. And at this time, I will offer Exhibit 124.
124. 124 is received.
Permission to publish 124. Right. If you could highlight the instructor block and title. All right, again, you see that this is the 2018, this training was provided on October 1, 2018, is that right?
Yes, sir.
And you are listed as one of the trainers, correct?
That's correct.
And if you could go to page 2 and highlight, please. And there you can see that the training was attended by the defendant. Is that correct?
Yes, sir.
You can take that down. How many times do you think you've provided training like what we saw in the exhibit to various officers over the years?
Hundreds of times, sir.
And is this a slide deck that you identified as being the 2018 version fairly consistent with prior versions of the use of force training you've provided?
The documentation, sir?
Yes.
Yes.
So when you do use of force training, there are generally two components, right? There's a classroom component, and then there would be, more of the tactical component, practical exercises. Is that right?
That's correct.
And what we saw in the exhibit was the classroom component.
I believe so.
Okay. Well, what I'd like to do now is publish Exhibit 119. And just like you've done hundreds of times before, I'm going to have you explain some of the selected slides to the jury. All right?
Yes, sir.
All Please turn to page 2, 119. And again, you can see your name listed on this in-service training as one of the instructors. Is that right?
Yes, sir.
And turn to page 4. Page 4 of the slide deck contains a policy reference. Is that right?
Yes, sir, it does.
And you testified that you're familiar with the policies, the use of force policies. One of the objectives of training is to impart the policies, teach those policies to the attending officers.
Yes, sir.
And so this is from the the Minneapolis Policy Manual 5-301. Could you please describe to the jury what this slide is intended to convey?
Yes, sir. Looks like there's 3 bullet points. The first one is sanctity of life and the protection of the public. That is the cornerstone of our use of force policies is the sanctity of life and the protection of the public. Also, clear and consistent force policies. We like our policies to be easily understood. And then the use of force standards do fall under the Fourth Amendment reasonableness standard.
And since we're talking about use of force, I'd like to turn to page 7 of the exhibit, 119. When we talk about use of force, explain to the jury what is force.
It's listed on this slide here. Intentional police contact involving any weapon, substance, vehicle, equipment, tool, device, or animal that inflicts pain or injury to another, physical strikes to the body, physical contact to the body that inflicts pain or injury, or restraint applied to manner or circumstance likely to produce injury.
So you train officers that restraint is a form of force, is that right?
Yes, sir.
And when applying force or applying restraint, the restraint has to be reasonable, correct?
Correct.
And it has to be reasonable at the time it starts and the time it stops?
Correct.
You're familiar with the concept of proportionality?
Yes, sir.
If you could turn to the exhibit page 8. When you discuss proportionality to trainees, you use this exhibit, is that right?
Yes, sir.
In general, without using the slide for a moment, just explain to the jury as you would a group of trainees, what is proportional force?
Well, you want to use the least amount of force necessary to meet your objectives, to control. And if those lower uses of force do not work, would not work, or too unsafe to try, then you can increase your level of force against that person.
You say do not work, would not work, or unsafe to try. It sounds like you maybe have used that phrase a time or two.
Yes, sir.
Is that a phrase that you've used in pretty much every training that you've given on use of force?
When there's a PowerPoint or we talk about use of force, we discuss proportionality regularly.
Okay. And you said that you want to use the least amount of force as necessary?
Yeah, yes, sir.
Why is that?
Because if you can use a lower level of force to meet your objectives, it's safer and better for everybody involved.
And when we talk about proportionality, is proportional to what?
I would say the level of resistance you're getting.
And the level of resistance would be dependent upon who?
The subject that you're using force upon.
The specific subject?
Yes, sir.
All right. At this time, I'm asked to publish Exhibit 110. And this is an item that's already been received into evidence. Do you recognize what's in Exhibit 110?
Yes, sir.
What is that?
Well, it's technically called the Defense and Control Response Training Guide, but a lot of people refer to this as a use of force continuum.
Okay. And we were discussing the concept of proportionality. You talked about subject behavior, is that right?
Yes, sir.
Subject behavior is over here on the left-hand side, correct?
That's correct.
And the subject behavior can vary from, I guess, nothing, passive resistance, all the way to active aggression, correct?
Yes, sir.
And then in terms of proportionality, there's various tools that are available to a law enforcement officer based on the subject behavior, correct?
That's correct.
And some of these tools, if we can take an example with active aggression, one response could be what?
Up to and including deadly force.
But then for lower levels of subject activity, such as passive resistance, right, that could include things like presence and verbalization. Right?
That's correct.
And is this something that you use with law enforcement officers you train to sort of graphically represent the concept of proportionality?
I'm not sure if we've used this specific to proportionality of force, but we have used this in the past to describe, like, as levels of resistance increase, that officers' response and also increases.
And similarly, as levels of resistance decrease, what should the officer do?
You should de-escalate use of force as well.
And that's actually listed on this response and control guide, isn't it?
Correct.
If you would clear that, Your Honor. And you'd indicated that you train officers that they should use the least amount of force that is available or that's reasonable under the circumstances. Is that right?
To meet the objectives, yes.
And explain that.
So you want to use the least amount of force to, if you're trying to control somebody, might be a lower level of force than if you're trying to get them in handcuffs and they're fighting. So you want to use the lowest level of force possible in order to meet those objectives.
And lower levels of force, fair to say, when you're using force, people can get hurt.
Yes, sir.
The subject can get hurt, the officer can get hurt.
Yes, sir.
Is that one of the reasons why it's better to use a lesser amount of force?
Yes, sir.
And another reason is that it's required. Is that right?
Yes, sir.
If you could go back to Exhibit 119 and publish page 12. And you train this to officers. This is back to your training materials. Is that right?
Yes, sir.
The Minnesota statutes provide, and this is integrated into the MPD policy, the concept of minimum restraint. Is that right?
That's correct.
And I'd ask you if you could please highlight the first section. I'm sorry, the second section. All right. What does the policy and the statute provide regarding the amount of restraint that can be used on an arrested subject?
The first line talks about the officer making the arrest may not subject the person arrested to any more restraint than is necessary for the arrest and detention.
What does that mean?
It means the minimum amount of force that you need to accomplish the objective of arresting and detaining somebody is what you should use.
Now, you're familiar with the circumstances that bring you here today. Is that right?
Yes, sir.
And I need to show you a photo that's been received into evidence, and it's Exhibit 17. If you'd like to publish that. Right. You see Exhibit 17, and you see the defendant on top of a subject that you know to be George Floyd. Is that right?
Yes, sir.
Is this a use of force?
Yes, sir.
If you could take that down, please. I want you to discuss, in terms of using force and using it safely, what you teach your trainees about sort of the frailty of the human body. It's important to be careful with people, is that right?
Oh, yes. It's very, very important to be careful.
And there's some parts of the body that are more prone to injury than others, correct?
That's correct.
And you train on that, is that right?
Yes, sir.
If we could display Exhibit 119, page 49. Now, this is from strike training, is that right?
That's correct.
But is it generally helpful in describing what some of the more sensitive parts of the human body are as you train Minneapolis police officers?
Related to strikes, yes.
Could it be related to other types of restraint as well?
I think you could stretch that some. I don't know exactly how to. What's the question exactly again? I'm sorry.
Is it fair to say that the areas that are marked in red, the red zones, are more prone to injury than other parts of the body? That could be serious.
Yes.
So, for example, the neck.
Yes.
And the head.
Correct.
And the sternum of the chest. Is that right?
Yes, sir.
And this wouldn't just pertain to strikes. It could also pertain to pressure, couldn't it?
Yes.
Is that something you probably knew before you even did any use of force training?
Yes, sir.
Well, I'd like you to then discuss with the jury the concept of neck restraints. And if we could publish it, page 52 of the exhibit. And looking at the time period that you were doing this training, neck restraints were authorized by MPD policy, correct?
Yes, sir.
Can you please describe the training that you provided to Minneapolis police officer regarding the use of neck restraints?
Yes, sir. We'd go over the techniques, definitions of neck restraints, and we'd go through different reps of the neck restraint to get the officers comfortable in doing it.
Could you just give the jury an overview of what a neck restraint is?
Yes, sir. So neck restraint is constricting the sides of a person's neck, and they refer to it as a vascular neck restraint. So you're slowing the blood flow to and from the brain with the intent to gain control of a subject.
And there are two different types of neck restraints in the MPD policy. Is that correct?
Yes, sir.
And those are what?
The two levels are conscious neck restraint. So that means you've wrapped somebody up and they're still conscious. And you can gain compliance with many people with that. And then there's unconscious, and that's applying pressure until the person, when they're not complying, you put enough pressure that they become unconscious and then therefore comply.
How does one actually apply a neck restraint?
We teach a couple of different techniques, but the basic idea is you use your elbow as a landmark and you place your arm across. So your bicep would be on one side of the neck and your arm would be on the forearm would be on the other side of the neck. And then there's a couple of different hand placements, but then you apply pressure with head pressure on both sides of the neck to gain compliance.
And you were demonstrating, you were using your arm to do that.
That's correct.
And it'll also be done with the leg.
It can be done with the leg.
Does MPD train on how to do it with the leg?
We may show the younger officers in the academy what that looks like, but we don't train leg neck restraints with the officers in service. And as far as my knowledge, we never have.
How would a trained neck restraint work? How would a trained leg neck restraint work?
People that watch MMA, so professional fighters, they call it a triangle choke, and I use that term choke loosely. That's just what it's called. But that's when you place your leg over somebody's back, across their side of their neck, and then you trap their arm in. So the person ends up having one arm in, and their arm causes pressure on one side, and the leg causes pressure on the second, and you can actually render somebody unconscious if you hold that long enough.
What part of the leg?
Usually it's the inner thigh.
Inner thigh. So in this scenario, using a leg to do a neck restraint, would the knee sort of replace the elbow in terms of placement? Or how would you describe it?
I would say the knee doesn't really replace the elbow. Your thigh would be across the side of somebody's neck, your leg across their back, and you protect the airway really with the space that's created with their arm being pinned in there.
If you could please display the next page, page 53. Use of neck restraints. Can you describe, in using those concepts of proportionality, when it's authorized to use a neck restraint of the two different varieties?
Yes, sir. On subjects who are actively aggressive, which means assaultive, they're actively resisting and other techniques haven't worked, you can use it then. And then on the bottom it says no, that you can't use it against subjects who are passively resistant.
And if you could go to the next slide, page 54. And after a neck restraint is applied, there are certain guidelines that you train that have to be followed. Is that right?
That's correct.
For the care of the individual upon whom the neck restraint was applied.
Yes, sir.
And if we could publish Exhibit 110 again, and bringing this specific topic back to the concept of proportionality. Could you enlarge this, please? Do you have one of those stylus up there?
Oh, I guess I do.
You can touch the screen and make a mark here. Unconscious neck restraint. An unconscious neck restraint is when the person would actually be rendered unconscious, correct?
That's correct.
And intentionally so.
Yes, sir.
Could you please underline unconscious neck restraint as you see it in this response and control guide?
Yes, sir.
And what subject activity, what level of subject activity would be required to use an unconscious neck restraint?
Well, according to this chart, it's in the red area, so it would be active aggression.
Okay. And do you agree with that?
Yeah. I think in the last slide we talked about active resistance if other techniques didn't work, but definitely in active aggression is where it's placed.
If we look then, you can also find a conscious neck restraint, and that's the neck restraint that's used for the purpose of control, correct?
Correct.
Could you underline where that is in this force continuum, Exhibit 110? And so the conscious neck restraint is authorized in circumstances where there's, in fact, active resistance. Is that right?
Yes, sir.
Okay. So then if there was something like passive resistance, right, neither the conscious neck restraint nor the unconscious neck restraint would be authorized. Is that right?
Would not be authorized?
Would not be authorized.
That is correct.
And an unconscious neck restraint would not even be authorized for some forms of active resistance, would it?
That's correct.
And if the subject is offering no resistance, obviously, then no neck restraint would be authorized.
That's correct.
Or any restraint. Would it? Or any restraint, if there's no...
Yeah, generally, no.
Okay. In addition to the classroom training, you actually teach officers, show them physically how to do these sort of neck restraints?
Yes, sir.
At this time, I'd like to republish Exhibit 17. Sir, is this an MPD trained neck restraint?
No, sir.
Has it ever been?
Not to my neck restraint? No, sir.
Is this a MPD authorized restraint technique?
Knee on the neck would be something that does happen in use of force that isn't unauthorized.
And under what circumstances would that be authorized? How long can you do that?
I don't know if there's a time frame. It would depend on the circumstance of the time.
Which would include what?
The type of resistance you're getting from the subject that you're putting the knee on.
Right. And so if there was, say for example, the subject was under control and handcuffed, would this be authorized?
I would say no.
If you could take that down, please. Continuing in this defensive tactics presentation, if you could go back to Exhibit 119, page 56. You also teach officers the proper handcuffing and techniques, is that right?
Yes, sir.
And according to the handcuffing techniques, they're to be handcuffed behind the back, and the handcuff is to be double locked.
Sure. Lieutenant, you can... Members of the jury, we're going to take our morning break. Let's reconvene at 11:15. Thank you. Lieutenant, you can step down for now.
Thank you, sir.
Page 56, and we're page 56, and we were starting to discuss what your training is regarding handcuffing. Could you please explain to the
Actually, you guys got to do this. Shoot.
EddieBlockFilms. EddieBlockFilms. You watching EddieBlockFilms. EddieBlockFilms. You watching EddieBlockFilms. EddieBlockFilms show. EddieBlockFilms. Watching EddieBlock. EddieBlockFilms. EddieBlock. The EddieBlockFilms show. EddieBlockFilms show. We are here, yeah. We watching Eddie, getting facts ready, keeping all the cameras steady, audio ready. So unlock, yep, and unload. Patriots prepared for the Eddie Block Show. EddieBlockFilms. EddieBlockFilms show. EddieBlockFilms. The EddieBlockFilms show. EddieBlockFilms. EddieBlockFilms.
Now I had to play that song, right?
jury how you train Minneapolis police officers in handcuffing techniques in the use of force?
Yes, sir. Well, we teach several different positional handcuffing techniques, as well as how to approach people when they're going to be handcuffed. And then once you make contact with the person, how to properly place the cuffs and procedures after.
How do you properly place the cuffs?
Well, one cuff at a time, and then once they're on and everything's under control in Code 4, as we call it, things have calmed down to the point where you have control of the subject. You want to make sure that you check the fit of the cuffs and double lock them for their safety. They tend to, behind your back, if you sit down, they tend to tighten up on a person. So we want to be mindful of the fit of the handcuffs.
And the double locking prevents the further tightening of the handcuffs?
Yes, sir. The double lock is just a little button that you use your cuff key to push, and it prevents the cuffs from either coming undone or going in.
And there's several different positions that an officer can be in when they're handcuffing a suspect. Is that right?
I'm sorry, can you
The
rephrase
officer
that?
could be in many different positions relative to the subject when they're handcuffing them.
Absolutely. Very dynamic. Yes, sir.
Standing.
Yes, sir.
Prone.
Yes, sir.
Right. And I'd like you to please describe for the jury what techniques are used to prone handcuff a subject.
With prone handcuffing, we want to make sure that we isolate an arm, and a lot of times we teach the officers to use a knee to control their shoulder. Generally, you put one knee on each side of the arm, so one would be on the upper shoulder, one about middle of the back, excuse me, and then isolate that arm, present the wrist for cuffing, and then handcuff. And a lot of times when you're doing the prone cuffing, you do that with a partner preferably. It makes it a lot easier to control a person.
And if someone is handcuffed and you're using your knee on their back or shoulder to gain control, do you leave it there for an extended period of time?
It depends on the circumstance. You can leave it there for a longer period of time, depending on the resistance you get.
And what would signal to you as a trainer when you're supposed to release your knee?
When their behavior de-escalates their resistance.
Relative to the handcuffing?
That's correct, sir. Yes.
Yeah,
Compliance.
No. So once you've accomplished the handcuffing, once the subject's actually been handcuffed, is that the appropriate time to release your leg?
Not necessarily.
Why?
When people are handcuffed in the prone position, they can thrash around, writhe around, and they do present a little bit of a threat. They can kick, bite, some other things. So control doesn't end with handcuffing always.
Mm-hmm. If the subject is resisting, correct?
That's correct.
The mere possibility that it's potential that a subject could resist like that, kicking, is that justification to leave your leg in place?
No, sir. I would say you need behavior that would lead you to leave your knee there.
So once the subject is handcuffed and compliant or not resisting, is the officer to remove their knee?
That would be an appropriate time.
And how long then is the person, the subject, to be left in the prone handcuffed position once they're compliant?
It depends on the circumstances that you're involved in with this person and the surrounding environment.
So assume the circumstances that I just stated. The subject is prone, handcuffed, and no longer resisting.
I think when it's reasonably necessary, you have the time to do it, then you should get them in a different position.
What position is that?
It depends on circumstances, but you can put them in the recovery position on their side. You can sit them up. You can stand them up.
And why would you want to put them into a different position?
There is the possibility and risk that that some people have difficulty breathing when the handcuffs are behind their back and they're on the stomach.
And what is that known as?
So, I'm sorry, rephrase.
Are you familiar with the phrase positional asphyxia?
Oh, yes, sir.
Is that the danger you would be trying to avoid by putting someone in the side recovery position?
That is one of the dangers you're trying to avoid, yes.
My previous suggestion.
Sustained. Last answer, stricken, rephrase.
You testified that you're familiar with the term positional asphyxia.
Yes, I am.
Okay. Why would you roll someone into the side recovery position after they've been handcuffed and are compliant?
Several reasons are there, but one would be to prevent a potential situation where they might be subject to positional asphyxiation.
And how soon is a subject to be placed into the side recovery position after they become compliant and no longer resistant?
When the scene is code 4 and you're able to do it.
Okay. In terms of subject safety, how soon should the person be put into the side recovery position?
I would say sooner the better.
Now, you testified that there are circumstances in which the subject can offer further resistance even though they're handcuffed. Is that right?
Yes, sir.
I'd like to direct your attention to page 58 of Exhibit 219. This slide discusses the maximal restraint technique. Is that right?
That's correct.
Is there a particular device that's used to accomplish the maximal restraint technique?
Yes, sir. It's the RIP restraint or the RIP hobble.
Okay. Can you please describe the maximal restraint technique to the jury?
Yes, sir. If you have a subject that is handcuffed behind their back, generally, and that's the way we like to handcuff people, and they continue to cause a threat to you or other people or themselves, we have taught our officers to use the maximal restraint technique, which is taking this RIP restraint, which is a nylon strap with a clamp on it, and you would wrap that around their legs and then connect it to the front of the body if possible, like a belt loop or a second restraint around their waist. And what that does is it bends their legs so that their legs are no longer a threat to kick out at you. Kind of put their legs at about a 90-degree angle so they're not able to extend the legs out to kick you if they are a threat.
Are you aware that the use of the maximal restraint technique is guided and governed by MPD policy?
Yes, sir, it is.
And that's 5-316?
That's correct.
All right. Is there more than one device that's authorized to perform the maximal restraint technique?
I believe it right now it's just the RIP hobble is the one we use.
And so if an officer reasonably believes that a subject is thrashing, would you recommend that they use this maximal restraint technique to ensure their safety?
Yes, sir.
And if they do so in accordance with MPD policy 5-316 in your training, what does the officer need to do after the subject has been placed in the MRT and is prone?
Place them in the recovery position.
How soon?
As soon as possible.
Why?
Because when you further restrict their ability to move, it can further restrict their ability to breathe.
Now, in terms of the appropriateness of force, would you agree with the proposition that force must be reasonable when it's applied?
Yes, sir.
And would you also agree that circumstances can change? Right? Subject behavior can change,
Yes, sir.
right? The environment can change.
Yes, sir.
And you familiar with Minneapolis MPD critical thinking model?
The critical decision-making model?
Yes.
Yes, sir.
Okay. And that's, kind of a graphic that I haven't asked the question yet.
Hard not to be leading with that. Let's try and rephrase this.
Is the critical thinking model a graphical representation of a different concept?
I don't know if I understand the question, sir.
Are you familiar with the concept of reassessment?
A reassessment? Absolutely.
Right. Can you describe reassessment to the jury?
Yes, sir. Through the critical decision-making model, we've put basically a template together for officers to look at and to understand their thinking processes. And reevaluation is when you're looking at circumstances that you're involved in, and you're constantly looking for factors to change so you can change your behavior.
And is reassessment something that you've been teaching even before the advent of this model?
Oh, yes. It's paramount to use of force.
And so there can be a point in time when a particular type of force is reasonable, but as time passes, circumstances can change?
Yes, sir.
And then that force would no longer be reasonable.
That's correct.
And if that's the case, what is the officer to do?
They're to change their force.
Thank you, Your Honor. I have nothing further.
Mr. Nelson.
If I may have just a moment, Your Honor. Good morning, sir.
Good morning.
I had to check the time. Thank you for being with us today. I have a few follow-up questions regarding the training the Minneapolis Police Department provides. You testified that one of your specialties, or I believe that you talked about how you developed the ground defense program.
I was one of the people that founded it, yes.
Okay. Can you just describe generally what is the ground defense program?
It's using techniques other than strikes to control individuals. I mean, that's the broad term.
And essentially that was a program that was introduced some 10, 15 years ago to the MPD?
I believe it's 10 years now.
Okay. And that's using different, like jujitsu moves or different body control methods versus punching or striking an individual, right?
That's correct.
And that was a program, again, that you helped develop and found, and you continued to train throughout the Minneapolis Police Department during your time as in the training division, right?
That's correct, sir.
And it's fair to say that when you train a police officer, you're training them in particular moves that will help improve their ability to gain compliance of a subject, right?
That's the goal, yes, sir.
But certainly there's no strict application of every single rule, agreed? Or every single technique.
That is correct.
Officers.
Objection. Which question was it for? Every move or every?
Objection sustained. Compound question. Rephrase.
Sure.
Answers are stricken.
There is no strict application of every technique that an officer is trained, is there?
No.
Officers are trained to be fluid, correct?
Yes, sir.
And sometimes officers have to do things that are unattractive to other people.
Correct.
In terms of the use of force.
Yes, sir.
And an officer, you would agree that being a police officer is a relatively dangerous job?
Yes, sir.
You yourself, in the course of your career, have had to use force against suspects?
Yes, sir.
You've arrested many people, I presume?
Yes, sir.
And would you agree that sometimes people aren't particularly happy about being arrested?
Very rarely, sir.
And sometimes they fight with you,
Yes, sir.
and sometimes they argue with you,
Yes, sir.
sometimes they make excuses.
Yes, sir.
And ultimately, one of the things that a police officer has to do is try to determine, is this person pretending or trying to give me some excuse not to get arrested, or is this person experiencing some other crisis, right?
Yes.
Right? And ultimately, in terms of an arrest, that's one of the things that an officer has to ascertain, right?
Yes, sir.
And again, when you've arrested people, have you had people plead with you not to arrest them?
Yes, sir.
Have you had people say they were having a medical emergency?
Yes, sir.
Have you had people say, I can't breathe?
Yes, sir.
And were there circumstances during the course of your career as a patrol officer where you didn't believe that that person was having a medical emergency?
Yes, sir.
And that's all part of the analysis in terms of the use of force, right?
It plays a part, yes, sir.
And so if someone comes to you and says, if you tell someone I'm under arrest, one way that a person can resist arrest is through the use of their words, agreed?
Yes, sir.
And that's a form of what you would call passive resistance?
Depending on the types of words that are used.
Right. So words could be both passive or active resistance, right?
I would say yes.
Right. So the difference between I'm having a heart attack versus screw you, you're not going to take me.
Oh, yeah, yes.
So that's what you mean by the difference in the words, right?
That's correct.
Or if a suspect is threatening you when you're arresting.
That's correct.
All right. Now, the whole concept of this ground defense program, as you testified, was to really use body weight and control to gain compliance of a subject, right?
Yes, sir.
And would you agree that in any use of force situation, the circumstances can change from minute to minute, second to second?
Yes, sir.
So somebody who is initially compliant can suddenly become non-compliant.
That's correct.
Somebody who's peacefully going into custody could suddenly become violent towards an officer.
That's correct.
Somebody who is violent in 1 second, becomes compliant, could become violent again, right?
Yes, sir.
You've experienced that yourself, correct?
I have.
And an officer, in terms of the use of force, you don't train officers specifically to only focus on the individual that they're taking into custody, do you?
No.
Do you train them on officers to consider and to take into consideration other factors?
Yes, sir.
Such as their partner's safety?
That's correct.
Such as a crowd?
Correct.
Such as the difference between a crowd, right? Like,
Yes, sir.
are they a happy crowd or are they an angry crowd?
Yes, sir.
In terms of, we talked about the proportionality of the use of force and kind of sliding force up and down that model. Do you recall that?
Yes, sir.
When an officer uses force, do you train officers to take into consideration what happened immediately prior to the use of a particular use of force?
Could you rephrase that, sir? I'm sorry.
Sure. In terms of the continuation of the use of force, do you train officers to take into consideration what has happened with that suspect in the immediate preceding events?
Yes, sir.
So, for example, if you were just fighting with a suspect and that person becomes compliant, does that become a consideration in terms of a continued use of force?
Yes, sir.
If someone has a sizable or a large size difference, do you train officers to take that into consideration in terms of their use of force?
Yes, sir.
So if some person had fought with more than one officer at a time? Do you train officers to take that into consideration as far as the continuing use of force?
Yes, sir.
So one person against 3 people is a factor that officers would consider for the continued use of force.
Yes, sir.
Do you train officers relevant to the use of force for people who are under the influence of controlled substances?
It's a consideration, yes.
And in your experience, have you ever had to use force against somebody who's under the influence of a controlled substance?
Yes, sir.
Do you train officers that certain controlled substances can cause a person to exhibit more strength than they would have otherwise?
Yes, sir.
So going back to the ground defense program, the ground defense program really uses a lot of joint manipulations, correct?
Yes, sir.
Pressure points.
Not so much pressure points with ground control.
Okay. Body weight pins.
Yes, sir.
Using the officer's body weight to physically control an individual, correct?
Yes, sir.
Now, you were previously interviewed by the FBI in connection with this case?
Yes, sir.
And you are aware that your statement was recorded, transcribed, and were you aware of that?
I was aware of that.
Have you had an opportunity to review your statement to the FBI?
Nope.
Okay. So I'm going to ask you just some general questions, and if I need to refresh your recollection, I'll do so. Okay?
Okay, thank you.
So, in terms of Minneapolis Police Department policy, there's a difference between a chokehold and a neck restraint, correct?
That's correct.
A chokehold is considered a lethal or deadly use of force, correct?
Correct.
And a chokehold is defined by Minneapolis policy as specifically blocking the trachea or the airway of the suspect from the front side, correct?
Correct.
So essentially what you would kind of think of as almost strangulation, putting your hands around someone's neck and squeezing the front of their neck, correct?
Yes, sir.
In this particular case, have you had an opportunity to review the body-worn cameras, the bystander surveillance, or the bystander cameras?
I have seen both, sir.
Okay. At any point, did you see Officer Chauvin use a choke hold in this case?
No, sir.
Now, in terms of neck restraints, you testified that you have been involved in the martial arts since college.
Yes, sir.
And I believe, if I'm not mistaken, that you also train MMA fighting.
No, sir, I do not.
Have you ever?
No, sir.
But in the course of your training, both in martial arts as well as like Brazilian Jiu-Jitsu, and your training to become a use of force instructor, you have experienced neck restraints, correct?
Yes, sir.
And you have taught individual officers, I believe you say hundreds of times, and hundreds of officers on how to use a neck restraint, correct?
Yes, sir.
And a neck restraint, as you have described it, requires both sides of the neck to be compressed in order to render a person unconscious, correct?
That is what we teach, yes.
How much pressure has to be applied to both sides of the neck in order to render a person unconscious based on your training?
It depends.
Okay. On what factors?
Size of the person, your skill, whether they're on narcotics or not, whether they're having an adrenaline rush, heart rate, general physical health. There's just a lot of factors involved.
Okay. Typically, do you have to apply a lot of pressure to, let's say, a healthy individual for a long period of time in order to render someone unconscious?
I would say no.
Right. Do you recall what is the percentage of pressure that you would generally expect to have to apply?
I don't know if I can.
Objection vague.
Overruled.
Question again, sir?
What amount of pressure do you have to apply typically in order to render someone unconscious?
I don't know if I can answer that. It's very individual.
Okay. So you said factors such as controlled substance use play into it, correct?
Yes, sir.
And if a suspect is on a controlled substance, does that speed up the process of rendering someone unconscious or slow it down?
I think my experiences are that it speeds it up.
And if someone has, you said another factor is if someone has an adrenaline surge, right?
Yes, sir.
And if someone has an adrenaline surge coursing through their body, does a use of a neck restraint speed up or slow, or does that adrenaline speed up or slow down the unconsciousness?
Objection, Your Honor. This is beyond his basic knowledge and the scope of the record.
Any more foundation?
Your Honor, I can refresh his recollection with his statement if that recalls.
Your Honor, do we have a sidebar?
No, proceed.
Would it refresh your recollection to review your statement relevant to adrenaline and the impact of how it speeds up or slows down a neck restraint?
I don't believe I need to see that.
Okay.
I know the answer.
What's the answer?
The answer is the higher your blood rate or your respiration and heart rate is, generally the faster a neck restraint affects somebody.
And how long, based on your training and experience, does it typically take to render a person unconscious using a neck restraint?
My experience is under 10 seconds.
Under 10 seconds?
Yes, sir.
Now, when a neck restraint is applied, does the Minneapolis Police Department specifically train people to be cautious when reviving or attempting to revive a suspect?
I'm not sure I understand the question, sir.
In your experience, after a person has been rendered unconscious using a neck restraint, is it possible for them to continue to fight after they come back to consciousness?
It is possible, yes.
Have you experienced that personally?
I have not experienced somebody fighting after a neck restraint.
Okay. But you're aware the Minneapolis Police Department trains people that is a possibility?
Yes, sir.
And in fact, sometimes they can be just as aggressive or even more aggressive after coming to consciousness.
That is possible, yes.
Now, in terms of the use of a neck restraint specifically, there are circumstances, are there not, where an officer can continue to hold a person in a neck restraint after rendering someone unconscious?
Hold somebody? Yes.
And for a period of time, correct?
Yes, sir. You can have your arm around their neck for a period of time, yes.
And there would be circumstances that would affect an officer's decision on whether to hold that person in that position for some period of time, correct?
Yes, sir.
That would include maybe waiting for other officers to arrive,
Yes, sir.
waiting for EMS to arrive.
I don't know about that. I wouldn't go that far, no.
Okay. You also train in the training department officers on what are called the human factors of force, correct?
Yes, sir.
And generally, can you describe what the human factors of force are?
Yes, sir. It involves either a startle response to the officer or getting scared or having an adrenaline rush or adrenaline dump in their body. And it affects your cognitive, physical abilities when you encounter stress like that.
So it's fair to say that when an officer is engaged in a use of force incident, him or herself, they may experience a rush of adrenaline as well, right?
Yes, sir.
You've experienced that yourself?
Yes, sir.
And after a situation has calmed down to some degree, the officer experiences an adrenaline rush, or dump, excuse me.
The adrenaline can continue to course through the body, yes.
And at some point it leaves.
Yes, sir.
And that adrenaline, officers are trained on this, correct?
Yes, sir.
It's a part of the standard training for both recruit officers in the academy as well as veteran officers in their in-service.
That's correct.
How frequently is the human factors of force taught to police officers?
I believe we teach it about once a year. We discuss the human factors of force.
You also train officers to be very much aware of their surroundings at all times, correct?
Yes, sir.
And you were asked a series of questions about continuing to hold someone in a prone position, and you use the term, you could hold them there until the scene is code 4. Do you recall that?
Yes, sir.
And so it's fair to say that the Minneapolis Police Department would train officers under certain circumstances to hold a person in a prone position until the scene is safe, correct?
There are circumstances where that is appropriate, yes.
And some of those circumstances could be the reaction of bystanders, correct?
That may be a factor, yes.
It could include where you are physically located in terms of a geographical area, correct?
Yes.
Right. Where you are in terms of other hazards that may present themselves to an officer or to the suspect, right?
Yes, sir.
Being in a busy street, in the middle of a busy street, versus being in a park or a yard or something.
Yes, sir.
Now, you also described the Minneapolis Police Department's policy in terms of rendering medical aid as best you can, right?
Yes.
An officer is required to do that, correct?
Yes, sir.
But there are certain circumstances, correct me if I'm wrong, where an officer has to consider whether it's safe for the officer to do so, correct?
Yes, sir.
And in fact, the training that Minneapolis police officers receive requires it to be safe for an officer to render medical aid. Agreed?
Generally, yes.
And one of the considerations an officer has to make in determining whether to render medical aid is whether or not the suspect is cuffed or uncuffed, right?
That may be a factor, yes.
There are circumstances where you've been fighting with a person and you've gotten them handcuffed, and you have to decide, is it worth the risk to take these handcuffs off to give this person medical aid?
Yes, sir.
Because once you unhandcuff a suspect, they could become resistant again, correct?
That is correct.
You have to decide, is that a risk you're willing to take?
Yes, sir.
You also described the recovery position, correct?
Yes, sir.
And the recovery position could be rolling someone on their side, sitting them up, or standing them up, right?
Yes, sir.
And again, there would be circumstances, you can envision circumstances where you would not put a person into the recovery position, correct?
Yes, sir.
And again, all of those factors that we've kind of talked about in terms of partner safety, personal safety, safety of the subject, safety of the crowd, all of those things are going through that critical decision-making model process, right?
Yes, sir.
Now, in terms of the use of body weight to hold a suspect, right? You train officers to use their knee across the back, shoulder, or the shoulder to the base of the neck of a subject, correct?
Yes.
That is something that is specifically trained by the Minneapolis Police Department, whether it be for handcuffing purposes or simply prone control of a subject.
Yes, sir.
So if a person is being handcuffed, officers are specifically trained to put a knee across the shoulder blade of the suspect to the trapezius, is that what it's called?
Trapezoid, yeah.
Something.
Yeah, sure. I'm not a medical doctor. So.
Yeah. And that is routinely trained by the Minneapolis Police Department, both in terms of the academy as well as in service.
Situationally, yes.
And simply because a person is handcuffed, there would be other circumstances where you would use that body weight, that prone control technique to maintain control of a subject, correct?
Yes.
And in terms of we could publish Exhibit 17, Your Honor. If we could publish Exhibit 17. You were asked a series of questions about whether this is appears to be a trained Minneapolis neck restraint.
Yes, I was asked that.
And you said no,
No.
correct?
Correct.
But it is, you had hedged a little bit and said it may be some other training.
Perhaps.
What would that training be?
Using body weight to control. However, I will add that we tell officers to stay away from the neck when possible, and if you're going to use body weight to pin, to put it on their shoulder and be mindful of position.
All right. If we can take this down, and just to the witness, I'd like to display a couple of This is page 41 of Exhibit 126. Just show this to the witness. Can you see that, sir?
Not yet.
Oh, sorry. Oop, this is already in evidence, but in this bottom corner here, do you see a photograph of an individual demonstrating how to handcuff a person?
Yes, sir.
And that knee is across the neck of that individual, correct?
The knee is on his far shoulder.
Across the neck, the base of the neck.
The shin would be from his toes up to the knee. Yes, the shin is across the back of the neck.
So that's when we're talking about prone handcuffing. This is a specific kind of photograph that demonstrates the placement of a knee as it applies to prone handcuffing, correct?
Correct.
And ultimately, if that person were to be handcuffed and circumstances dictated, the officer would be permitted to continue to hold his knee in that same position. Agreed?
I would say yes. However, we've cautioned officers that be mindful of the neck area and to look for the shoulder for placement.
Perfect. We can take this down. Can we take that down, Your Honor? I'm going to show you what has been introduced as Exhibit 56 already. Can you see that, sir?
A little glare, but yes, sir.
It appears to be the
Sure. Yes, sir.
it appears to be the paramedic checking the carotid pulse of Mr. Floyd.
Yes, sir.
In your experience, this is already admitted as Exhibit 56. In your experience, would you be able to touch the carotid artery if the knee was placed on the carotid artery?
No, sir.
So I'm showing you what's been marked for identification purposes as Exhibit 1045, 1045. Can you just generally take a look at that?
Yes, sir.
Now, in terms of, do you recognize that this appears to be a still photograph taken from the body-worn camera of one of the involved officers?
That's what it appears to be, yes.
There's a timestamp on it that indicates May 25th, 2020 at 20:23:32.
Yes, sir.
And can you see two officers in this area here holding Mr. Floyd?
Yes, sir.
And if I can clear this. Here, does that appear to be the placement of one officer's knee and leg?
Yes, sir.
Does that appear to be across the shoulder blade to the base of the neck?
The shin appears to be across the shoulder blade. I don't know if I can tell you where the knee is.
So we'll just, I would offer 1045.
Any objection?
Foundationally, Your Honor,
Officer King.
no objection.
All right, 1045 is received.
Permission to publish. Can we clear that? Oh, okay. So what we're seeing here, again, this is at 8:23 and 32 seconds, correct?
Yes, sir.
And obviously this is taken from one of the body cameras, and here you can see down in that area the leg placement of the officer, correct?
Yes, sir.
And based on your observation of this photograph, it appears that the shin is coming from the top of the shoulder across the shoulder blade, correct?
Yes, sir.
And it appears to be at an angle pointed in towards the squad car, correct?
Yes, sir.
All right. If we could take this down, Your Honor. I think I accidentally closed. Hang on one second. Sure, I'm showing you what's been marked for identification purposes as 1046. Does that appear to be a similar angle?
Yes, sir.
And I apologize, it was actually Officer Lane's body-worn camera. 1045 and 1046. Again, can you see what appears to be the placement of the leg of one of the officers at the shoulder blade of Mr. Floyd?
It appears so.
You can see in this area here what appears to be the back or the calf area coming across the shoulder blade, correct?
Yes, sir.
Again, the time stamp is 10:26 and 40 seconds.
Yes, sir.
And does that knee placement appear to be similar to Howell, Minneapolis, or excuse me, similar to the placement in the previous exhibit?
The last exhibit, sir?
Yes.
Yes.
And that was roughly a couple of minutes after, right?
Yes, sir.
I would offer exhibit 1046.
Any,
Just for clarification, did you say 10:26 and 46 seconds? Did you mean
8:26 and 40 seconds. 20, 26, 40.
No objection.
1046 is received.
Permission to publish. So again, it's a little hard to see in this particular photograph, but if we look in this general area here, correct? You can see the placement of the knee, correct?
I can see the general area of the placement of the knee, yes.
And again, here we have what appears to be the shin coming over the top of Mr. Floyd's shoulder blade.
That's what it appears, sir.
And that would be angled in towards the squad car, correct?
Correct.
You take that down, Your Honor. Sir, I'm showing you what's been marked for identification purposes as Exhibit 1047. Does that also appear to be a still frame image taken from a body-worn camera of a Minneapolis police officer?
Yes, sir.
Timestamp being 8:27 and 49 seconds.
Yes, sir.
20/27/49, correct?
Correct.
And it appears that the officer wearing this body-worn camera has now stood up, correct?
It's a different angle, sir, yes.
From higher to lower, correct?
Lower to higher, sir?
It appears that the camera is at a higher angle, looking down.
Yes, sir.
And can you see in this photograph what appears to be the knee and shin placement of the officer?
Yes, sir.
And would you agree that it appears that the knee is placed in the center between Mr. Floyd's shoulder blades?
It appears to be between his shoulder blades, sir, yes.
I'd offer 1047.
Any objection?
Lane,
No objection.
1047 is received.
permission to publish?
You may.
So again, here in this particular photograph, you can see the placement of Mr. Chauvin's knee in between the shoulder blades of Mr. Floyd, correct?
Yes, sir.
And it happens to be right here, that moment when the carotid artery is being palpated by the EMT.
Yes, sir.
We could take this down. Let me show you one last photograph, sir. Again, does this appear to be a photograph taken from, or a still frame image of a Minneapolis police body camera?
Yes, sir.
Time being 10:28 and 29 seconds.
Yes, sir.
Excuse me, 20:28, 29,
20/28, 29, sir, yes.
which would be 8:28:29.
Correct.
And again, can you see the placement of Officer Chauvin's knee?
Yes, sir.
Can you see Mr. Floyd's head?
Yes, sir.
I'd offer 1048.
Any objection?
Yes, they're all lane.
No objection.
1048 is received.
Permission to publish? And again, it's a little hard to see here. You can see Mr. Floyd's head in that area,
Yes, sir.
and Mr. Chauvin, Officer Chauvin's knee between the shoulder blades of Mr. Floyd.
Yes, sir.
Does this appear to be a neck restraint?
No, sir.
Does this appear to be a prone hold that an officer may apply with his knee?
Yes.
You can take that down here. Now, you have talked about taking or holding a person in the prone position after they have stopped resisting. Do you recall talking about that?
Yes, sir.
And are there circumstances in your career where you have had to use your body weight to hold a suspect down for longer periods of time than, say, 2 or 3 seconds?
Yes, sir.
And are there times where you have had to use your body weight to hold a suspect down for 10 minutes?
I'm not sure if I have held somebody down for 10 minutes or not. I don't have a recollection of that, sir.
Is it possible?
Yes, it's possible.
And there are circumstances, again, that an officer has to take into consideration in terms of continuing to use their body weight, regardless of whether the person is resisting or not resisting, right?
Rephrase that?
Sure.
Sorry, guys, had to talk down my
Sometimes an officer
veteran.
has called for EMS, correct?
That's correct.
And sometimes an officer may hold a person using their body weight to restrain them, awaiting the arrival of EMS, correct?
Yes, sir.
You've done that yourself?
I have.
And sometimes you've had to, or was it fair to say that you've had to train officers to use their body weight to continue holding them until EMS arrives?
As long as needed to control them, yes.
You would agree that a scene where force has been used and a crowd congregates and is voicing their displeasure or their concern or whatever you want to say, that can be a chaotic situation for an officer, right?
Yes, sir.
And you would agree also that what you train Minneapolis police officers to do, relevant to their use of force, is to consider the totality of the circumstances. Agreed?
Yes, sir.
And you train officers that the decision to use force is from their perspective,
Yes, sir.
not the perspective, hindsight being 2020.
That's correct.
That's the specific policy of Minneapolis Police Department.
I believe that's Graham versus Connor, sir.
That is encapsulated or incorporated into the Minneapolis Police Department policy on the use of force, correct?
Correct.
Because situations are rapidly evolving, correct?
That's correct.
And sometimes just because an incident is 10 minutes long or 20 minutes long, that doesn't mean that it can't instantaneously change.
That's correct.
Right? What may not be a threat 1 second can be a threat the next.
Correct.
Have you ever been trained or trained others to say that if a person can talk, they can breathe?
It's been said, yes.
In terms of the continuation of the use of force, right? Or excuse me, not the use of the continuation. The graphic that we looked at in Exhibit 110. If we could publish Exhibit 110, Your Honor. This is the Defense Control and Response Training Guide, correct?
That's correct.
Simply because a person is not actively resisting, right? That doesn't mean you can't use some degree of force, correct?
That's correct.
If a person is passively resisting, you can still use certain types of force, right?
Yes, sir.
That's down in this area here, correct?
Correct.
And that would include the use of joint manipulation, escort holds, pressure points, correct?
Yes, sir.
We could take that down here. Sorry, if we could take it down. You were asked a series of questions about the strike chart and the neck, the red, yellow, and green zones.
Yeah, it's called the Monadnock chart, sir. Yes, for striking.
That chart is designed specifically for punches, baton strikes, things of that nature, correct?
That's where we use that graph, yes.
In terms of the maximal restraint technique, you were describing the use of the maximal restraint technique.
Yes, sir.
And again, officers are trained to sometimes escalate the use of force in certain circumstances, correct?
Yes.
And de-escalate the use of force in certain circumstances.
Yes, sir.
If an officer decides initially to use the maximal restraint technique and then subsequently decides against it because of a medical situation or because of a lack of resistance, or would that be a de-escalation of the use of force?
Yes.
Is it more or less difficult to render medical aid if someone is in the maximal restraint technique?
I would say it was probably a little bit more difficult to maneuver around that.
You would not be able to put them on their back, for example.
It would be difficult, sir, yes.
In terms of the use of force, part of the ground defense program is actually to use body weight as a form of de-escalation, is it not?
Yeah, it's use of force that may be used instead of higher escalations of force, yes.
But sometimes holding someone in a position can be a de-escalating technique.
Yes, sir.
And ultimately, again, in terms of the use of force and deciding how much force should be used, the difference in size of an officer to a subject is a consideration,
It is a consideration, yes.
as well as the presence of other officers, right?
Yes, sir.
You would agree that basically the use of force in any circumstance is incredibly dependent upon the situation.
Yes, sir.
And when an officer is using force, they are to employ the critical decision-making model, correct?
They should be using that at all times.
But including the use of force.
Yes, sir.
And that critical decision-making model is not simply focused exclusively on the subject of the force being used, correct?
It's a situational awareness tool.
And the situational awareness extends beyond just the subject.
That's correct.
It extends to numerous factors.
Correct.
I have no further questions, Your Honor.
Mr. Slusher.
Thank you, Your Honor. Sir, to follow up on some questions that counsel is asking you regarding the use of force being reasonable in the eyes of the officer. That's what you answer the training is that right?
At the officer involved at the moment the force is used, yes.
But force is always subject to review, correct?
Yes, sir.
And review is always going to be after the fact, right?
That's correct.
And the force that's used and reviewed must be reasonable.
That's correct.
Taken from that perspective, the perspective of the officer at the time, correct?
That's correct.
But the officer doesn't have the unfettered discretion to use whatever force they wish.
No, they do not, sir.
Now, if we could publish the Exhibit 110 again, which is the control guide continuum. Now, when we look over here on the left-hand side and we're talking about what force can be used and what's proportional, we see that the officer is to look at the subject behavior. Is that right?
For force on the subject, yes, sir.
And the amount of force that they use that's proportionate has to be proportionate to the subject's behavior, correct?
Generally speaking, yes.
So if, for example, a group of bystanders were doing something that the officer might find annoying, such as videotaping, right? That act would not be subject-controlled behavior, would it?
No, sir.
And that act would not justify the use of force or escalation of force by the officer, would it?
That alone, sir, no.
Because that's not subject-controlled behavior, correct?
Correct.
So if we could then publish Exhibit 184. Exhibit 184 has been received into evidence, and what you see here is a group of bystanders. Is that right?
Yes, sir.
And in a couple of instances, you can see the bystanders have something in their hands, correct?
Yes, sir.
And those appear to be video cameras. Is that right? Or smartphones.
Yes, sir.
That extra fact would not justify an increased use of force, would it?
Just the camera, sir? No.
If you could take down Exhibit 184. The acceptable use of a knee across a subject's back it's a transitory position, is that right?
Yes, it is.
It's meant to be used to gain control of the subject while the subject is being handcuffed, correct? But all force must end at some point, is that right?
That is correct.
And once a subject is under control and no longer resistant, it's inappropriate to hold them in a position where you're draping your knee across their back or neck, isn't it?
I would say it's time to de-escalate force, sir.
And get off of them.
Yes, sir.
You talked about the prone position in and of itself being something that can lead to positional asphyxia, is that right?
Yes, sir.
Would that risk be increased by the addition of body weight?
Yes, sir.
And so if an officer was placing body weight on the knee, with the knee on the neck or the back, or the the neck and the back, that would transfer the officer's body weight onto the person, correct?
Yes, sir.
And that would increase the restriction, I guess, decrease the ability of the subject to breathe. Is that right?
Potentially, sir, yes.
And it would not be, or I have to ask you, would that be appropriate to hold someone in a position where it's more difficult to breathe for an extended period of time after the subject has stopped offering resistance?
Can you rephrase that, sir?
Would it be appropriate and within training to hold a subject in that prone restrained position with a knee on the neck and a knee on the back for an extended period of time after the subject has stopped offering any resistance?
No, sir.
Or has lost their pulse?
No, sir.
You testified that an individual can be unconscious one moment and then suddenly become conscious and become violent, correct?
That is potentially, yes, sir.
Have you ever had a circumstance where an individual has lost their pulse and suddenly come back to life and become more violent?
Not that I'm aware of, sir.
Nothing further.
Any further requests?
Sir, in terms of the use of force and the continuation of the use of force, you were just shown Exhibit 184. I'm going to ask to republish 184. Looking at this individual right here, does it appear that the man in blue is holding back the man in black?
Yes, sir. The guy with the boxing shirt on?
Yes,
sir. He's holding back. That's at a glance.
Yep. Now, in terms of the continuation of use of force, and we're talking about involvement of onlookers, right? The words they use matter, correct?
Yes, sir, they do.
If they're cheering on and saying, "Good job, officer," that's one consideration, right?
Correct.
But if they're saying, "I'd slap the fuck out of you," or "You're a pussy," or "You're a chump," would that reasonably tend to rise alarm in a police officer?
Yes, sir.
I have no further questions.
And if they're saying, "Get off him, you're killing him," should the officer also take that into account and consider whether their actions need to be reassessed?
Potentially, sir, yes.
Nothing further.
Thank you, Lieutenant.
Thank you, sir.
You're
Your Honor.
excused.
Appreciate that.
Members of the jury, we're going to take our noon recess. I have 2 meetings, so we won't be able to reconvene until 1:30. Thank you.
You watching EddieBlockFilms, EddieBlockFilms, you watching EddieBlockFilms, EddieBlockFilms show, EddieBlockFilms, watching EddieBlockFilms, EddieBlockFilms, EddieBlockFilms show. Yeah, we watching Eddie, getting facts ready, keeping all the cameras steady, audio ready.
They make
So
all sense with this.
yep, and a low patriot prepare for the Eddie Block Show. Eddie Block Films, Eddie Block Film Show, Eddie Block Films, Eddie Block Film Show, Eddie Block, Eddie Block Films, Eddie Block, Eddie Block Films.
Thank you, Your Honor. The state calls Nicole McKenzie.
Raise your right hand. You swear or affirm under penalty of perjury that the testimony you're about to give will be the truth and nothing but the truth.
Yes, Your Honor.
Good seat. And if you feel comfortable doing so, we'd prefer that you take your mask off.
Certainly.
And before you begin,
Actually,
could you grab me that stylus that's there? Thank you. Yeah, I'll get one for you. If you could begin by giving us your full name, spelling each of your names.
Nicole McKenzie, Nicole. Last name McKenzie, Mackenzie.
Mr. Slisher.
Good afternoon.
Good afternoon.
How are you employed?
I'm employed by the Minneapolis Police Department.
How long have you been employed by the police department?
About 6 years.
What is your current role there?
I am a police officer.
Do you have a specific duty assignment?
I do. I'm the medical support coordinator for the department.
All right. Now, before we talk about that role, I'd like you to share a little bit about yourself with the jury. How long then have you been a police officer or in law enforcement?
I've been in law enforcement for about 6 years, all of that whole time with the Minneapolis Police Department.
And did you have a career prior to going into law enforcement?
I did, yes. I worked in human resources.
What's your educational background?
I have an associate's degree in human resources. I have a bachelor's degree in business. I am an EMT. I also have my law enforcement certificate, and I'm also an EMR instructor.
You worked in human resources. That was your original plan?
Correct.
How long have you wanted to be a police officer?
Actually, it's something I had always wanted to do. I just kind of talked myself out of it for one way or another, but eventually found my way back.
Can you please tell the jury how you entered law enforcement? Did you go through the academy?
I did, yes. I came in as a cadet, which means that the department sponsors the education components that make you eligible for the post-exam in the state of Minnesota.
Okay. And how long of a program was that?
I think it was about 9 months total.
After you completed the in-class or the classroom portion of the academy, did you go through field training?
I did.
How long was that process?
The field training at that time was about 5.5 to 6 months.
And as an officer with the Minneapolis Police Department, are you familiar with some of the officers who also work in the department?
I am.
Are you familiar with the name Derek Chauvin?
I am.
How are you familiar with that name?
He was actually one of my fill-in FTOs for one day while I was on FTO. I think my FTO was sick, but also he's attended my training that I've conducted with the department.
All right. And would you recognize him if you saw him?
Yes.
Do you see him in the courtroom today?
Yes, sir.
Would you please point to him and describe what he's wearing?
Yep. It's the gentleman here in the light gray suit.
All right. May the record reflect the witness has identified the defendant.
Any objection? It will.
You indicated that you're the medical support coordinator, is that right?
Yes, sir.
Could you please describe for the jury what that role entails?
Certainly. There's a couple different components to it. Primarily, it's going to be the first aid education that all of the officers receive. I do the training for the academy, both the recruits and the cadets, as well as the in-service, which is more like the continuing ed for all of the current officers. And I am also administrator of the Narcan program that we have.
What is the Narcan program?
The Narcan program is the training and administration of pharmaceutical to use to temporarily reduce opiate overdoses.
And is Narcan, is that something that officers have available to them
Yes, sir.
And you provide the specific training regarding the use of Narcan?
I do.
Okay. And also, you provide medical training both at the academy and in service, is that right?
Correct.
Are you familiar with the requirements from the department and the post requirements for how often officers are supposed to train in medical procedures?
Yeah, with the Minnesota Post Board, when you're able to apply for the examination, you do have to have your EMR certification, and that's Emergency Medical Responder. Beyond that, the Post Board doesn't require anything terribly specific, but with the Minneapolis Police Department, we do continuing education every year on medical-related topics.
You said that the Post Board doesn't require anything more specific. Can you explain that?
With their education requirements as far as the continuing ed, as long as you've met the minimum number of hours, there are certain topics that they require you to complete. Other ones, because with the Minneapolis Police Department, we go above and beyond what the Post Board requires. So that's where we add in extra medical training.
And you do that every year?
We do.
Are police officers required to have a specific CPR card?
Not a card, no. You're not required to have that beyond your initial post certification.
When you're initially post certified, you need one.
Correct.
And
that's a part of the EMR certification that's required to be eligible to take the post exam.
And some officers will continue to obtain the CPR card, is that right?
Correct.
You know what is required in order to obtain that card?
It's about a 4-hour class. There's a written test and a skills examination test out.
And what does it cover?
It includes adult CPR and AED, infant CPR, AED, as well as choking.
Now, at this time, I'd like to display to the witness and not to the jury Exhibit 277 for identification. If you take a look at what's been marked for identification as Exhibit 277, does that appear to be an American Heart Association CPR AED card?
Correct, yes.
Is that the type of card that you get issued if you complete the 4-hour course you just mentioned?
Yes.
While it's not required, some officers continue them, and those cards are maintained in the records of the Minneapolis Police Department. Is that right?
If they had taken a full AHA course through the Minneapolis Police Department, we would be the record holder.
All right. And then if we can take a look at Exhibit 278, that also appeared to be a CPR card, just of a different year.
Correct.
Okay, I'm going to offer Exhibits 277 and 278.
277 and 278 are received.
If we could publish Exhibit 277 and highlight the portion thing. Does this appear to be a Heart Saver CPR AED card issued to Derek Chauvin, March 2012 through March 2014?
Correct.
Okay. And if we could display Exhibit 278. Again, a CPR card issued to the defendant from January 2014 to January 2016. Is that right?
That's correct.
And then when you provide the training, the medical training to law enforcement officers, does that training get reported into the workforce system to be able to report to the post board?
It does.
Now, when did you start personally delivering this training?
I had been a part-time instructor since 2017, and I assumed the full-time position January of 2020.
Okay. How many times do you think that you've provided this training, this in-service training to law enforcement officers?
CPR specifically?
Yes.
I would say upwards of 20 to 30 sessions.
All right. Do you use a slide deck or a PowerPoint to do your medical presentation every year?
We do.
If I can show you Exhibit 111, just to the witness, not to the jury. Okay. Exhibit 111, do you recognize what appears to be the first part of a slide deck?
Yes.
And if we can turn to the second page of 111, does that appear to have, it says MPD CPR? Is that right?
Correct.
Have you personally delivered this slide deck before?
I have.
Approximately how many times?
This was in service of 2019, and my best estimation, this was probably carried out over the course of maybe 12 sessions or so, 12 to 15 sessions, and I was responsible for about a third of them.
Right. But did the defendant attend any of your sessions?
I'm not sure.
But you were providing the block of training that everyone consistently took back in service in 2019?
Correct. I was the assistant instructor here, and I ran one of the skill stations. So theoretically, everybody from the department would have come through my skill station at some point.
Now, at this time, if I can, you can take that down here. I'm going to offer Exhibit 111.
Any objection? 111 is received.
In general terms, then, you provide the jury an overview of the specific medical training that you provide to law enforcement officers on an annual basis.
For in-service specifically?
For in-service, yes.
Okay. We do offer a wide variety of different kind of trainings, depending on how many training sessions are going to be available to us in a year. But at a minimum, every year we are touching on CPR and AED. And then in alternate years, we're also going over a refresher class on Narcan. Okay. And that's the minimum standard. If we have more training spots available to us, we can add in more classes.
And are you aware whether the Minneapolis Police Department has a specific policy regarding rendering of emergency aid?
We do.
And could you please provide the jury just a high-level overview of what that policy requires?
Certainly. It's a high-level summary of our first aid policy is going to be requesting EMS resources to anybody that needs it or anybody who requests it, and also rendering first aid that's consistent with your training that you've received.
Okay. And does the policy allow you to do one or the other? Can you just call for the ambulance and not do the emergency medical procedures?
It depends on the situation specifically. If there was really no need for immediate first aid, maybe like a small cut or abrasion, it would be then appropriate to just wait for EMS to arrive. But if it's a critical situation, no, you have to do both.
I'd like you now to kind of walk us through some of the specific training that you provide, and we'll use Exhibit 111 to do so. If you could publish Exhibit 111 starting at page 6. Well, let's go back to page 1. All right, why don't you explain page 1 of this?
Okay, so this is an image of a clip that's taken from the classic movie Dumb and Dumber. And this is a video clip that we show at the very beginning of training. It's more or less just kind of a lighthearted way to get people a little bit more engaged in the class. As
not a substantive slide.
No, absolutely not.
All right. Now, I'd like to then cover the substantive portions. If you could go to page 6 and review the portion of the slide deck that says agenda. You please describe to the jury each of these different portions of the training that you provide.
Certainly. So this block of training was primarily focused on CPR, but we did throw in a couple of extra pieces of information because we had the time available to us. So we just kind of briefly retouched on other things we had had already taught, which was tactical combat casualty care. That's basically rendering aid for more traumatic injuries, if you will. Then we also provided an update on our Narcan program as far as usage and maybe things we had learned since we had initially had rolled it out. And then the remainder of the time was focused on the full CPR course.
All right. If you could go to page 21 of Exhibit 111. And for the jury, would you please describe, then, using this slide, just kind of walk us through what specific training you provide Minneapolis Police Department as it pertains to CPR?
Okay. When we're called to a scene where there is some kind of medical situation going on, maybe it's illness or injury, whatever it happens to be, we have a little bit of a mnemonic that we always kind of walk through to make sure that we're covering all the basics. So when you're encountering somebody that appears to be unconscious, we start with an acronym that's called AVPU. That's AVPU. We walk through that acronym to determine a level of responsiveness. And then we kind of work through the A, B's, and C's, which is airway, breathing, and circulation.
Right. I'd like you to then please go to the next page, 22. AVPU, could you please walk the jury through this assessment tool?
Certainly. So when you're determining somebody's level of responsiveness, you kind of walk through this as your model to see where they land. So if somebody's alert, that means that, as soon as I walk into the room, and they spontaneously look at me, I determine, okay, that person's alert. I don't really need to go any further. Verbal would be, maybe just kind of yelling towards somebody or trying to get their attention, something like that, to see if they respond to any verbal stimuli. And if you don't get a response there, then you move on to the P, which is pain. And that's going to be something like, for instance, if you grab the base of the fingernail and kind of press against it, you're just kind of looking for any kind of response that somebody would normally pull away from. We're certainly not talking about anything that would, cause any injury per se, but just a little pain stimulus, see if they kind of pull away from you or something like that. And if they don't respond, then you determine that person is unresponsive.
I'd like to just talk about, have you talk about the P, the painful stimuli, briefly. It sounds like in the assessment tool, what the person is doing, the trainee is doing, is going to be applying a painful stimulus to see if the person reacts. Is that right?
That's correct.
Is it possible to determine someone's level of responsiveness without intentionally, or should I say, without inflicting pain for the purpose of checking stimuli? So, for example, just observing whether the person is continuing to react to some kind of painful stimulus.
Can you rephrase that?
Sure. If you came upon an individual who was injured, for example, and crying out or manifesting some sort of pain as a result of the injury, but at some point they stop being verbal, they stop responding to that pain, could that potentially be a sign of non-responsiveness?
Correct, yes.
Okay. Once you determine an individual is unresponsive, then what do you do?
Then you walk through the next set of acronyms, which is going to be your A, B's, and C's.
If you could return to page 21, please. Okay. And the A, B's, and C's, that's airway, breathing, and circulation. Is that
That's
right?
correct.
Okay. And if you could go to page 23. Can you please describe to the jury then what you train officers to do based on this slide within Exhibit 111?
Certainly. After you determine their level of responsiveness, if they're unresponsive, you're going to first address their airway, and that means just putting them in the most ideal physical position where their airway can be as most in line as possible.
And then what's the next step?
Tilting up the head slightly to open up their... whether you use a head tilt chin lift or a jaw thrust maneuver to open up their airway. Okay. And then the next step beyond that is moving into checking for breathing. And if you don't see chest rise, it's just a matter of putting a hand on the center of the chest and seeing if there's any kind of air moving up and down.
Right. And then what's the next step?
The last is circulation. So that's where we're going to be checking a carotid pulse right up here underneath the jaw.
Are there other places that officers are trained that they can use to check for a pulse aside from the carotid?
Yep, absolutely. You can, use your radial here at your wrist. There's multiple points on your body where you can check them, but this is by far and away the most important.
Okay. And what are officers trained to do if they are unable to find a pulse?
If you don't have a pulse on a person, you'll immediately start CPR.
Now, I want to go back to the concept of checking for breathing. You indicated that you can look for the chest rising and falling. Is that right?
Mm-hmm. Yes. Yes.
All right. Do you train officers that, as part of your training, you train officers that if a person can talk, means that they can breathe?
No, sir.
Okay. Why not?
Well, that would be incomplete to say, because there is a possibility that somebody could be in respiratory distress and still being able to verbalize it. Just because they're speaking doesn't mean they're breathing adequately.
All right. And getting back to circulation, you indicated that if the officer cannot find a pulse, they're to start CPR. Is that
Yes, sir.
correct? And describe what is done to start CPR.
So to start CPR, if you're going to be starting that, if you haven't already contacted EMS to get them en route, you would do that immediately. Then it's a matter of just interlocking your fingers, and you go center of the chest, and then you push down about a third of the depth on that person at the rate of about 100 beats per minute.
And is this something, that, again, getting back to the MPD policy, that the officer is trained that they're required to do while they're waiting for the ambulance?
Yes.
And when is the officer supposed to stop CPR?
When you've been relieved by somebody with a higher level of training than you, or if there was some obvious signs of death, or if you've been doing it for a while, if you're absolutely just physically exhausted from doing CPR.
If you could display page 27 of the exhibit. Right. And officers are specifically trained on this, is that right?
Correct.
It can be when the subject becomes responsive or wakes up.
Right.
Or someone else takes over. Or as you stated, it's not safe or you physically can't do it anymore. Is that
Correct.
Right?
Yes.
Okay. And is this consistent then with the training that you provide every year to each and every law enforcement officer who is recorded as having taken this training during in-service?
Yes.
All right, I have nothing further. Thank you, Your Honor.
Mr. Nelson. You may.
Sidebar. Like I said, she can arrest me anytime she wants.
Sorry about that, ma'am.
No worries.
All right, I think I'm ready now. Thank you for joining us today. Just a few follow-up questions. You have been with the Minneapolis Police Department for about 6 years at this point?
Correct.
And prior to that, you said you were an EMT as well, right?
Correct.
Now, as far as the Minneapolis Police Department is concerned, there are officers are trained as essentially first responders, correct?
Correct, with the EMR certification.
Right, emergency.
Medical responder.
And so it's sort of it's a lower level of medical training, correct?
Than an EMT, that is correct.
Right. So you may go to a CPR class, then you have your first responder, and then an EMT paramedic, correct?
That would be a natural progression, yeah.
Right. And so you have experience, did you work as an EMT as well as?
I did.
Okay. And so you have experience both as a police officer as well as an EMT, correct?
Correct.
Now, you testified that part of your role now as running the medical program is to present officers with information as to multiple medical issues that they may encounter.
Correct.
It's not just limited to first aid or first responder, CPR type stuff, correct?
No, we also teach like wellness classes, whether it's sleep, nutrition. We have a wide variety of classes.
Okay. And you have classes on topics including excited delirium?
Correct.
And you have topics including the administration of Narcan?
Correct.
And officers, are all Minneapolis police officers permitted to carry Narcan, assuming they've had the training?
Yes.
And do all Minneapolis police officers receive that training?
Yes.
And so some of these medical topics at these continuing education classes, they may come up an hour here or a half hour there during an in-service, right?
Depends on the topic, yes.
Right. So the EMR stuff is kind of a standalone class. There may be, that's a longer class, right?
Correct. That's basically your initial medical training, as you're required to get as your post certification. That's about a 40-hour class.
Okay. And then you'll have refresher classes on that stuff as well, correct?
It'll contain many of the same topics, but the Minneapolis Police Department doesn't require officers to keep their EMR certification.
Okay. All right. And so the certification that we saw Mr. Chauvin had expiring in 2016, I believe.
That was CPR.
The CPR. Yep. And are officers required to then have CPR every 2 years after that?
Yeah, we do CPR classes on a rotating basis, so that every other year they go through CPR.
All right. Now, I would like to talk to you about a couple of the Minneapolis policies, if we could. So there's essentially two Minneapolis police policies that deal with emergency medical response, correct?
Correct.
One being after a use of force, correct?
That is correct.
And that being as soon as reasonably practical, determine if anyone was injured and render medical aid consistent with training and request EMS if necessary, correct?
Correct.
That's policy 5-306 involving a use of force, correct?
Yes, sir.
And so the policy is somewhat qualified, correct? Meaning it's as soon as reasonably practical, correct?
Correct.
So in the course of the medical training, one of the things that you train officers to do in the administration of first aid is to consider other circumstances, right?
Correct. You'd have to make sure that your scene is safe before you're able to render aid.
Right. And there's the scene being safe could be, not being safe could be come from a number of factors, correct?
Absolutely.
Environmental factors such as where you're located, right?
Yes.
Whether there's a lot of traffic, correct?
Yes.
Or whether there's a lot of bystanders, correct?
Correct.
Depending on their behavior, right?
Yes.
Okay. So scene safety is important, and in fact, Minneapolis police or the EMTs won't come to a scene until it's declared code 4 generally, correct?
Generally, yes.
And so oftentimes it's not uncommon for EMTs to stage off-site until police call a scene code 4, correct?
Correct.
Code 4 being all clear, all safe, come on in.
Yes.
And so in that situation, if a scene is unsafe, EMTs don't come in at that point.
Correct.
Right? The other policy that we deal with here too many things open here. Is policy, Minneapolis Police Policy 7-350. That's in front of you right now?
It is.
And again, instant or relative to the emergency medical response, Minneapolis police officers are required to request EMS as soon as practical, correct?
Correct.
And so there may be certain things that prevent an officer from calling in EMS, right?
Absolutely.
So both of the medical policies are somewhat qualified or contingent upon what's going on at the scene at the time, right?
Yes.
Now, in terms of believe it was this. Exhibit 111, which is the CPR presentation that you've presented. Turn to I'm going to turn to Bates 21856 down at the bottom there. There is a reference to agonal breathing.
Yes.
What is agonal breathing?
Agonal breathing is something you'll see in somebody who's unresponsive and they're in some sort of respiratory distress. We see this quite often with opiate overdoses, medical emergencies, drownings, what have you.
And can you describe what exactly agonal breathing is?
Well, by name, it's kind of a bad term for it because it's not effective breathing. It's more or less kind of an irregular gasp for air.
Okay.
It's really just kind of like your brain's last ditch effort to try to pull some air in.
And a person observing someone going through agonal breathing, it's common, or it would be possible that they would misinterpret that as actual breathing, effective breathing.
Yes, it can be easily confused with real breathing, so that's why we teach this is not effective breathing.
Right. So an officer is dealing with someone who's experiencing agonal breathing. It would potentially be possible for an officer to misinterpret agonal breathing for effective breathing.
Okay.
And in certain circumstances where there's a lot of noise or a lot of commotion, would it be more likely that that could happen?
Yes.
Now, you were shown this slide in terms of when do we stop CPR, and one of the reasons you stop performing CPR is because it's not safe, right?
Correct.
And by it being not safe, are you referring to the process of actually giving CPR or the environment that you would be doing it in?
It would be the environment around you.
Okay. And so it stands to reason that if the environment around you would determine to be not safe, you may not start it right away.
That would be reasonable, yes.
Okay. Now, you also testified that you teach on Narcan and the use of Narcan.
Correct.
And I am going to show you. You can see this training in front of you.
Yes.
Is this training that you provide to Minneapolis police officers?
Yes.
And this is the this is the program on, like, the broader course on how to administer Narcan, correct?
Correct.
And do you recognize this is a record that you keep in the ordinary course of your business?
Yes, sir.
This, Mr. Slisher, I had labeled as Exhibit 1041. And I would move to admit Exhibit 1041.
No objection.
1041 is received.
I don't know why it's doing this. Here we go. And permission to publish 1041. This is from the Minneapolis Police Department in service from July of 2018.
Correct.
And if Mr. Chauvin had attended this program and or his in-service in July or through September of 2018, he would have received this training, correct?
Correct.
Now, in recent years, fentanyl has become more of a concern for officers to be aware of, correct?
Absolutely.
And ultimately, you train officers in the use of Narcan to contraindicate, or to contradict, I should say, the effects of Narcan, right? Oh,
The effect of opiates.
Opiates, including fentanyl.
Correct.
Right? Now, in your experience as a police officer and as a medical trainer, have you experienced individuals who take combinations of drugs?
Yes,
Have you heard the term speedball?
I have.
And would you agree that that is generally the combination of both a stimulant like methamphetamine and a depressant like fentanyl?
Yes.
And
Sidebar, Your Honor?
We need a sidebar on that board.
can you describe for the jury what a speedball is?
It's essentially a combination of an upper and a downer.
And has that become commonplace in your experience?
Yes.
Now, as fentanyl has become more prominent, do you see that in legal forms, such as patches or other pills that may be administered by a hospital?
Objection leading.
Do you see that on the streets?
Yes, you'll see totally legitimate pharmaceutical purposes, and then also illicit, drugs that were manufactured outside of compliance.
Can you explain for the jury whether, in your experience, you've seen illicit fentanyl use on the rise?
Yes,
Becoming more
absolutely.
And I'm going to just show you, generally when you talk about someone, you show it to officers in this training, when someone is on the experiencing an opiate overdose, you may see this type of behavior. Is that correct?
You could, yes.
Someone may fall asleep, someone may be very tired, kind of out of it, right?
Correct.
Yeah, let's get back to the right question.
Sorry. Would this be consistent with what you would see generally on a opiate overdose?
It could be.
Have you ever been at a scene where an opiate overdose, someone can be more responsive,
Yes,
even though they've taken an opiate?
correct.
Now, in terms of fentanyl, can you explain this slide?
Certainly. So this is a diagram to show you just what could be considered a lethal dose of fentanyl. Just it's more of a visual indicator because we already know how dangerous heroin is, and you can see a trace amount of that could be deadly with fentanyl, and even more so with carfentanil.
And so even fentanyl, even in very small doses, can be fatal. Would that be accurate?
Objection, Your Honor. Sidebar.
I'll rephrase the question.
Persist in the objection, Your Honor.
Oh, it's a lengthy title. What's up? That's amazing.
So these are the training materials that you present to Minneapolis police officers relevant to the use of Narcan and controlled substances that they may encounter while in their performance of their duties, correct?
Correct.
All right. Now, in terms of, and we can take this down, in terms of just again, general training, you had already said that you also discussed with officers the concepts of excited delirium, correct?
Correct.
And you provide them with training and materials about what that means, correct?
Yes.
All right. And generally speaking, without reviewing to your training materials, can you describe what you train Minneapolis police officers about excited delirium?
Certainly. And this is a class that is taught at the academy. It's a 1 hour block of 1 hour block of instruction to recognize the signs and symptoms of excited delirium and your best responses for handling that. So excited delirium, it's a combination of psychomotor agitation, psychosis, hypothermia, a wide variety of things you might see in a person with rather bizarre behavior. And recognizing that this is a medical condition, not necessarily a criminal matter.
Would that include discussion of controlled substances in the context of excited delirium?
Yes, because what we're usually teaching is that most of the people that are experiencing something like excited delirium, usually there's illicit drugs on board that might be a contributing factor.
And as far as what do you train Minneapolis police officers relevant to the physical attributes of a person experiencing excited delirium?
The person might be experiencing a hyperthermia, means elevated body temperature. That could be displayed with somebody taking off their clothes in a place it's not appropriate to take off your clothes, or in like the middle of winter or something like that. And just based on their activity, their heart rate might be extremely elevated, and they might be insensitive to pain.
How does it affect strength?
Because you don't really have that pain compliance that would normally otherwise kind of control somebody's behavior. So somebody experiencing this, they might have what we call superhuman strength. They might be able to lift things they wouldn't normally otherwise be able to lift. They might be breaking things where they then have blood like substances that you need to be cautious of.
Thank you. Now, in terms of, I'm going to just back up and talk a little bit more about the response to a medical emergency by EMS, again, based on your experience as a police officer and an EMT. You talked about how sometimes EMS will stage off-site until a scene is clear and safe, correct?
Correct.
And have you heard the term load and go?
Yes.
Can you describe for the jury what that is?
Load and go, that would be, I think it's more like an informal term that's used with first responders. That essentially means that as soon as they're going to be arriving, it's a priority to get that person into the ambulance as soon as possible and get en route to the hospital as soon as possible.
Are there reasons why an EMT would, or a paramedic would choose to do that rather than administering first aid at the scene?
Yes.
What are those reasons?
This goes beyond the scope of the training.
If you know. If you don't know, just say so.
Sure. I feel comfortable answering it. And by way of example, if maybe somebody had a knife in their chest, obviously there's only so many things you can do for that person pre-hospital. Really the only thing that's going to save that person is immediate surgery.
Sure. So there may be conditions of the individual that warrant that type of pick up and go?
Yeah.
And what about people in the area? Could that affect an EMT's decision to load and go?
Yes.
How so?
If you had a very hostile or volatile crowd, I know it sounds unreasonable, but bystanders do occasionally attack EMS crews. So sometimes just getting out of the situation is kind of the best way to diffuse it.
Okay. And have you ever had to perform emergency services in not even a hostile crowd, just a loud, excited crowd?
Yes.
Is that, in your experience, more or less difficult?
It's incredibly difficult.
Why?
Because if you're trying to be heads down on a patient that you need to render aid to, it's very difficult to focus on that patient while there's other things around you. If you don't feel safe around you, if you don't have enough resources, it's very difficult to focus on the one thing in front of you.
It can be distracting.
Absolutely.
And so does it make it more difficult to assess a patient?
It does.
Does it make it more likely that you may miss signs that a patient is experiencing something?
Yes.
And so the distraction can actually harm the potential care of the patient.
Yes.
I have no further questions.
Are officers trained that sometimes they have to provide emergency medical services in less than ideal conditions?
Yes.
The rendering of emergency aid in practice does not happen in a classroom setting, does it?
Correct.
Right, and so you're in the environment as you find it, is that right?
Yes.
And in terms of a crowd and a crowd being hostile, how would you define hostility?
That would be a growing contingent of people around if they're, yelling, being, even verbally abusive to those that are trying to provide scene security.
Okay. What else?
If there's people trying to interfere with a crime scene or, interfere with a patient. Absolutely.
Perhaps use a weapon?
Yep.
Throw rocks or bottles?
Yes.
Something like that could prevent someone from providing emergency aid, is that right?
Absolutely.
Can the activities, though, of a crowd, or the activities of a group of onlookers excuse a police officer from the duty to render emergency medical aid to a subject who needs it?
Only if they were physically getting themselves involved, I would say.
If they were physically prevented, if the officer was physically prevented from doing it?
Yes, if the officer is being physically assaulted.
I wanted to talk a little bit about some of the things you said were indicative of excited delirium. You said superhuman strength, is that right?
Yes.
And I think what you said was that it was because of the inability to feel pain, is that right?
That's a part of it, yes.
And the inability to feel pain is something that you associate with, or you train officers to associate with excited delirium?
That it could be a case of excited delirium, yes.
And so if someone was actually manifesting a response to pain, indicating that something was hurting them, then that would tend to indicate that they're not suffering from excited delirium. Isn't that right?
Rephrase.
What would a subject's response to pain stimulus suggest then, as it relates to excited delirium?
That, it may or may not be excited delirium. It's a little bit hard to predict because no two people ever really present the exact same way.
So then how do you tell what it is?
Well, that's not up for us to diagnose. It's just a matter of taking in the information you have at that time to decide if this could potentially be a case of that, or you just need to plan accordingly.
And you indicated that whatever excited delirium is, you look at it as a medical issue.
Correct.
That needs treatment.
Yes.
And in terms of drug use as well, it's fair to say that if someone is showing indicia of drug intoxication, it can make them vulnerable.
Yes.
Not just violent.
Correct.
Thank you. Nothing further.
Members of the jury, let's take 10 minutes. We have to deal with one issue. A witness will remain, however. So 10 minutes and we'll be back in touch.
Oh, I thought we were going to get to hear it.
Where the state objected the hearing of the jury, but on the record. There was a sidebar at some point where the state objected to the excited delirium training material. And essentially, I think, Mr. Slisher, I don't want to speak for you too much, that your preference would be that Mr. Nelson not be allowed to present it at this time, but only as part of his case in chief, which would require this witness to come back during his case in chief. Is that correct?
It is.
All right, and so that's the basic objection, is the timing as opposed to the admissibility.
Yes, sir.
Okay, Mr. Nelson, what did you want to deal with?
If we could have a private conversation.
All right.
See, when they got the mask, you can't read their face, you can read their lips.
I'm going to excuse you for the day. She can be excused at this point, is that correct?
Yes.
You can be excused for the day, but the defense would like to call you back during their case. And so Mr. Nelson will serve a subpoena on you at some point so that you've got it mostly for his contact information.
Sure.
Because in the interim, I'm going to order that your subpoena that you were previously served still is in force, and that you should, unless you hear otherwise, come next Tuesday at 9 a.m. But most likely, Mr. Nelson will be in contact to tell you when exactly, so you don't just waste your time coming down here.
Yes, sir.
Does that work?
Understood. Yep.
Okay. So, Mr. Nelson, how is that going to be served?
Department.
Normally, yes.
So I can just serve the police through the normal or through the federation or something.
Yeah, absolutely.
All right. We'll make sure that gets done. But for today, you're excused. Thank you. All right. We'll be in recess until 2:35 at least, if not 22.
All right, you know what happens when we're fast forwarding.
EddieBlockFilms. EddieBlockFilms. You watching EddieBlockFilms. EddieBlockFilms. You watching EddieBlockFilms. EddieBlockFilms show. EddieBlockFilms. Watching EddieBlockFilms. EddieBlock, the EddieBlockFilms show. EddieBlockFilms show. Yeah, we watching Eddie getting facts.
Members of the jury, just so you know, we'll probably have another short break. It probably won't be our full 20, but just if you're wondering, are we going to be pushing through? No. We all need to stay well. And so we're going to take another break eventually this afternoon. Mr. Swisher, you may call your next witness.
Thank you, Your Honor. The state calls Jody Steiger.
You can stand right here. Sure. Raise your hand. Do you swear or affirm under penalty of perjury that the testimony you're about to give will be the truth and nothing but the truth?
Yes, I do.
Have a seat. Right here. That. And if you wouldn't mind, if you would use this to grab that stylus that's there and give it to me. All right. Thank you. And we're going to swap it out with it. And I'd ask that you remove your mask if you feel comfortable doing so.
Yes, sir.
And let's begin by having you state your full name, spelling each of your names.
Yes, sir. Jody Steiger, Jodystiger.
Mr. Swisher.
Thank you, Your Honor. Sir, how are you employed?
I'm employed with the Los Angeles Police Department.
In what capacity?
I'm a sergeant.
And you understand that you're here today serving as a retained expert for the state in this matter, is that correct?
Yes, sir.
So this is outside your typical duties as a sergeant with the LA Police Department, correct?
Yes, sir. I'm on vacation.
All right. Well, welcome to Minnesota.
Thank you.
Sir, before we begin your testimony, I'd like you to just introduce yourself and share a little bit about your background with the jury. First, how old are you?
I'm 50 years old.
Okay. And you indicated that you're currently a sergeant with the LAPD. Can you please describe for the jury how you came to be involved in law enforcement?
Yes. So shortly after leaving the Marine Corps, I joined the Los Angeles Police Department in April of 1993. Yesterday was my 28-year anniversary. Did the police academy. After graduating the police academy, I was assigned to a patrol division, and from there, I was recruited to work undercover in the high schools to buy drugs.
In Los Angeles high schools?
Yes.
Okay, and you were working as an undercover?
Yes.
How long did you have that assignment?
Approximately 6 months.
What did you do after that?
After that, I was assigned to another patrol division in South Los Angeles, Southwest Division, near the campus of University of Southern California. and I worked there until 1998.
All right. And what were your duties just generally as a patrol officer in that particular area of Los Angeles?
For the first 2 years of patrol, was just handling calls for service primarily. During that time, it was a pretty violent time in Los Angeles. I believe on average, in our division, we averaged anywhere from 100 to 200 homicides a year. So it was a pretty dangerous area.
Okay. And after then, you said you held that position as a patrol officer for how many years?
Just for patrol specifically, I was there for 2 years, and then I was recruited to work the gang unit at the same division.
In the same geographic area?
Yes.
Describe that work for the jury.
It was primarily gang intelligence. I was assigned a specific gang and neighborhood, and our assignment was to gather intelligence, make arrests, and handle any calls of service that were specific to that specific gang.
How long did you work in the gang unit?
In that specific gang unit for 3.5 years.
Okay. And where did you go after that?
I was recruited to go and work at FBI task force in the same bureau for specific to that gang that I was assigned to in Southwest Division.
And was that more of a long-term investigation?
Yes. So we were doing investigative work, and so basically we handled all crimes other than murders and sexual assaults that were committed by that specific gang.
Right. And how long did you do that?
I did that for approximately 1.5 years.
Then where did you go?
Then I was recruited, and I was assigned to the training division at our for in-service tactics.
And approximately what year was that?
Approximately 2000.
And what did you do for your in-service tactics unit?
For the in-service tactics unit, we developed a 32-hour course. It was the first of its kind for the Los Angeles Police Department. It was a 4-day course where we went over de-escalation, firearms manipulation, basic patrol tactics, and arrest control techniques.
Okay. And what was your assignment afterwards?
After that position, I was promoted to sergeant.
And you spent some time on the use of force board for your department?
Yes, as a peer member.
What does that mean?
So the way the Los Angeles Police Department's use of force review is set up is there's 3 stages. So initially you have a use for, these are for the higher profile uses of force, not all uses of force, the higher level uses of force. So you have a use of force review board that convenes, and there's 4 command staff and 1 peer member. So depending on the officer involved, if it's a police officer, then you have a peer that's an officer. If it's a sergeant, detective, so on and so forth. And so I was a peer member from 2003 until 2007. So I was a peer member as a police officer as well as a sergeant, where I sat on the board as a board of 5 people, 4 command staff and the peer, and basically we review all the information that was gathered during the investigation, and we make recommendations to the chief of police. At that point, the chief of police then gets that information. He makes a recommendation to the police commission, and then the police commission has the final say.
And what you're reviewing is actions, conduct involving uses of force of other officers. Is that right?
Yes, sir.
And then what was your next assignment after serving on that board?
That was just an adjunct duty, so I was called as needed. But as I stated earlier, I was promoted to sergeant in 2006, and I was assigned to our central division, which is downtown Los Angeles.
What was required to become a sergeant for the LAPD?
You have to take a written test, and once you pass the written test, you also have to go through an interview process, and then you're ranked. You also have to have a certain amount of college credits in order to be eligible to take the test.
You were then eventually selected as sergeant. Can you tell the jury what your first duty was as a sergeant?
Yes, my first duty was assigned to our Central Division, which is downtown Los Angeles, in the Skid Row area.
In the Skid Row area?
Yes, sir.
And doing what?
I was a patrol sergeant, a field sergeant.
So describe what that job was like. What were you supposed to do?
General duties of a field sergeant is supervising officers assigned to a specific watch. Normally, anywhere from 10 to 20 officers would be assigned to a specific watch, and you may be one or two supervisors that are assigned to that watch as well. And you have general duties such as providing roll call training in the early beginning of the watch, as well as just overall supervision, making sure that officers are conducting themselves properly, as well as if there's a use of force, you have to respond to the use of force and take the use of force investigations as well.
And did you take a different position after serving as a sergeant?
I'm still a sergeant, but yes, within about 6 months, I was assigned to our Safer Cities initiative, which was focused on the homeless problem in Skid Row area. So I did that for the next year and a half.
Now, you've described a couple of geographic areas of Los Angeles in which you've served as a patrol officer and a patrol sergeant.
Yes.
I'd like you to please just describe in general terms those areas in terms of the dangerousness or the crime rate there.
Well, in my first assignment in South Bureau, South Bureau historically has the highest violent crime in the city. Central Bureau and Central Division usually is second or third.
Right. And what kind of crimes are you typically responding to?
Primarily violent crimes, robberies, assaults, things of that nature.
And I'd also like you to just describe for the jury the training that you received in the use of force and defensive tactics to help you do your job as a patrol officer and a patrol sergeant.
I was unique in a sense because I was a tactics instructor for 6 years. So I had a lot of background in use of force and tactics prior to making sergeant. Prior to that, as a patrol officer, we would get quarterly training as well as annual training that would keep us up to date on any changes in laws or policy and procedures.
And what does it mean to be a tactics instructor?
For our department and for the state of California, you have to go through different types of training. So I've been through our force options instructor training, as well as de-escalation training. I'm a trainer for de-escalation, force options. I've been through the FBI range matcher course, so I'm a handgun instructor as well, and a number of leadership courses as well.
Okay. And have you had an educational role or a teaching role within your department?
Yes, as I stated earlier, for 6 years I was a tactics instructor for in-service training for the course I had mentioned earlier.
So this in-service training would be for already serving officers, is that right? Experienced officers?
Yes.
It would be in the form of annual training?
Yes.
Okay. During that annual training, would you provide training as to your department's use of force policy?
Yes, and state law.
And state law. And have you reviewed generally use of force policies and across the nation and compared those with the use of force policies in your department?
Yes. So at my current position, I am the aide to the Inspector General, which is an oversight entity that is within the Los Angeles Police Department, independent of the department itself. I'm the only sworn officer that works for that unit. There's 28 overall employees. During my time there, I was able to travel nationwide and go to a number of different police agencies to basically compare their use of force policies as well as their training with Los Angeles Police Department.
And are your policies in the Los Angeles Police Department fairly consistent with the policies and standards nationwide?
Yes, sir.
Is there sort of a nationwide sort of acceptable reasonableness of a police officer that's generally accepted in your field?
Overruled.
Yes.
Getting back to your days as a trainer for defensive tactics and instruction, approximately how many Los Angeles police officers did you provide training in that 6-year time period?
In the initial 6-year time period, approximately 3,000 officers.
And can you explain to the jury the types of training that you provided, the specific topics?
As I stated earlier, the main focus was de-escalation. We taught them basic patrol tactics such as vehicle stops, pedestrian stops, as well as firearms manipulation, and ultimately we would do at the end of the 4-day course, the goal was for them to utilize their de-escalation tactics so they wouldn't have to use force.
Did you teach specific tactics, ground training or anything like that?
No, we taught all the subjects.
Right. Now, you indicated in your current role with the department you do use of force reviews. Is that correct?
No, not in my current role.
In a prior role, I should
yes.
say you did. Okay. And in terms of the use of force reviews and the numbers of use of force reviews that you've completed in your career, can you estimate approximately how many you've done?
Approximately 2,500.
And of those 2,500 force reviews, have you ever made findings that the use of force was excessive or objectively unreasonable?
Yes.
And have you ever made findings where such use of force was not excessive?
Yes.
And when you've done use of force reviews, has that included the review of the use of deadly force?
Yes, in certain situations, primarily in that role. After being a patrol sergeant, I was promoted and assigned to be a training coordinator for South Bureau, which is pretty much all of South Los Angeles. In that bureau, we had approximately 1,600 officers, and at the time it was 4 patrol divisions and 1 traffic division. And so my job was to oversee the training for that bureau.
Are you a member of any professional organizations?
Yes, I'm a member of a few.
Could you name them, please?
Employee organization, the Oscar Joe Bryant Foundation, which represents African American officers on the police department. I'm a member of I'm drawing a blank, I'm sorry. A number of them, I'm trying to not say the acronyms because then I got to say them all out. But a number of other police organizations that involve tactical managers.
And have you been called upon by other law enforcement agencies to provide instruction in the use of force?
Instructions specifically, no. I've consulted with a number of other agencies.
Consultation of use of force reviews?
Yes.
Okay. What other agencies have you assisted?
I've assisted the University of California, Office of the President. I've assisted King County, Office of the Ombudsman. I've assisted California City Police Department, as well as the University of California, Irvine Police Department.
Did you, and you have indicated already that you've been retained as an expert witness for the state in this matter, is that right?
Yes, sir.
And you've conducted then a review of some of the various materials associated with the death of George Floyd that happened on May 25, 2020, is that correct?
Yes, sir.
Do you charge a fee for your services?
Yes.
And can you please tell the jury what the fee is in this matter?
There was a flat fee of $10,000, and for trial, the fee is $2,950.
And that has included reviewing all of the different offense materials that you were provided, is that right?
Yes, sir.
And could you please tell the jury, just in general, high-level terms, what offense materials you have reviewed?
I reviewed all the body-worn videos, all the other videos that were provided to me that were cell phone videos, poll videos, things of that nature, reports, manuals from the Minneapolis Police Department, as well as the training materials.
One moment, if we may have a sidebar, Your Honor.
Sorry, I'm right there, guys.
All right, based upon your review of the different materials that you have conducted in this case, and based upon your own experience and training in law enforcement, have you reached an opinion as to the degree and amount of force used by the defendant, Mr. Chauvin, on George Floyd?
Yes.
Okay. And can I ask you to explain to the jury a little bit about what process or methodology you go through to render such an opinion?
There's a few steps. The main step is going through the objective reasonableness standard, which is based off of Graham versus Connor. You're looking at the seriousness of the crime, looking at the person's actions, things of that nature, as well as looking at the specific agencies' policies and procedures as well.
Okay. In addition to the seriousness of the crime under the Graham standard, do you look at any other factors?
Yeah, I try to look at a number of factors. What was known to the officers at the time, and again, like I stated, one of the biggest things I look at is what was the person's actions at the time that the officer was using force.
All right. And based upon your review of these materials and in light of the Graham factors, what is your opinion as to the degree of force used by the defendant on Mr. Floyd on the date in question?
My opinion was that the force was excessive.
Before we then talk about that, the specific basis for that, we need to define a few terms. What is force?
Force could be typically what officers would use in a law enforcement perspective. Obviously, force is different techniques and tools that officers may use to try to take someone into custody or apprehend the person or to control them.
Can force include a restraint?
Yes.
If I may show you Exhibit 17, which has been received into evidence. All right. Can you describe what it is you see here?
I see a officer with his knee on the neck of Mr. Floyd.
Is this a form of force?
Yes.
Now, and you can remove Exhibit 17. Oh, I'm sorry. That was supposed to be published.
Oh, I'm sorry.
That's okay. If you could republish the exhibit then, 17. This is specifically what we're talking about in terms of the force you were reviewing. Is that right?
Yes, sir.
And the force that you stated, in your opinion, was excessive. Is that the force that began right around the point that Mr. Floyd was on the ground?
Yes, sir.
All right. Now, I'd like to then focus your attention to the Graham versus Connor factors. You indicated that one of the factors that you consider is the severity of the offense being investigated. Is that right?
Yes, sir.
And do you recall what was the severity of the offense being investigated here?
If I remember correctly, it was Mr. Floyd was accused of having a counterfeit $20 bill.
And how does that particular offense or the severity of the offense relate to the appropriateness of the force to be used against him?
Typically, in a normal situation where you're dealing with someone that's a counterfeiter or someone who is using a counterfeit bill, typically you wouldn't even expect to use any type of force.
When you're looking at in the Connor standard, the severity of the offense, is the label of the offense, be it a misdemeanor or felony, is that important?
In some cases, yes.
What do you find more important than the label of the offense?
The person's actions.
And so would it be fair to describe the counterfeit $20 bill as a fairly low-level offense?
Yes.
And in the Connor world, then, that would justify lesser force, is that right?
Yes, sir.
Then the second factor is whether the person would pose some sort of an immediate threat. Is that correct?
Yes, sir.
Can you describe to the jury what is a threat?
A threat can be perceived as something where an officer feels that the person is going to assault them or going to assault someone else.
And is identifying a level of threat, is that an objective standard, a subjective standard? How is that viewed?
It could be subjective.
Okay. How so?
Depending on the officer, their training and experience.
Okay. And when we talk about threat, I'd like you to distinguish between a threat and a risk. Is there a difference between a threat and a risk?
Yes.
Explain that difference to the jury.
So typically as police officers, anytime we go into a situation, there's a risk factor involved just based on the nature of policing. It's kind of, I try to describe it as when I'm teaching, I describe it as if you're going into the middle of a movie and you don't know what's going on, so you're trying to figure out all the information as you're going through. As far as a threat is concerned, a threat would be once someone becomes combative or assaultive towards you or towards another person.
Now, what kind of factors can present a risk?
The location, just the mere call itself, the call for service, what the actual crime was.
What about the characteristics of the subject? What characteristics of the subject can pose a potential risk?
I'm sorry, could you?
For example, the size of the subject.
Yes, in certain instances, size and stature do make a difference.
Okay. In terms of a risk, is that right?
Yes.
Is the size of a subject, would a large subject necessarily constitute a threat?
No, not necessarily.
And why is that?
Again, it's based on the person's actions, not specifically just their size and stature.
And so in conducting a use of force review or looking at the objective reasonableness of force, is it appropriate to use force against an individual simply because of their larger size?
No.
And I'd like you to discuss the Connor standard of resistance, whether the person is resisting or attempting to evade law enforcement officers. Is that something you review?
Yes.
Okay. And were you able to make any kind of assessment in this case as to whether or not Mr. Floyd was offering resistance or trying to evade law enforcement officers?
Yes.
Okay. And what was your assessment?
Initially, when Mr. Floyd was being placed in the backseat of the vehicle, he was actively resisting the officers. So at that point, the officers were justified in utilizing force to try to have him comply with their commands and to seat him in the back seat of the vehicle. However, once he was placed in the prone position on the ground, he slowly ceased his resistance, and at that point, the officers, ex-officers, I should say, they should have slowed down or stopped their force as well.
Okay. Now, I'd like to back up to a certain point. You indicated.
Could you state the question again?
And so I asked you to make an assessment as to the reasonability of the force that was used by the law enforcement officers as it relates to whether or not Mr. Floyd was offering any kind of resistance. Is that, you recall that?
Yes, sir.
And I believe you indicated that Mr. Floyd was offering resistance initially outside of the vehicle. Is that right?
Yes, outside and inside the vehicle.
Okay. And then, however, there was a time that Mr. Floyd was taken outside of the vehicle and placed on the ground. Is that correct?
Yes, sir.
And you indicated at that point, after he was placed on the ground, the officers, what should they have done?
They should have de-escalated the situation or attempted to.
And what did they do instead, based on your review?
They continued the force that they were utilizing from the time that they first put him on the ground.
Right. Now, I want to make sure that when we're talking about the evaluation of the use of force, you're evaluating this application of force from what perspective?
First, I look at it from a ground perspective, as well as the Minneapolis Police Department's use of force policy.
And is the standard then through the view of a reasonable police officer on the scene?
Yes.
And since we're talking about the actions specifically of the defendant, at what point are you going to be determining or considering the factors that were available to the defendant when he was applying force?
I'm sorry, could you rephrase that?
Yeah. So we know that there were some events that happened prior to Mr. Chauvin, the defendant's arrival on the scene. Is that correct?
Yes.
Right. But for the purposes of your review of the reasonableness of the defendant's actions, at what point do you begin your analysis?
Based on when he arrived and he became involved in the actual use of force.
And so, based on your review of the materials, what were the circumstances on the ground or at the scene for the defendant when he arrived?
When he arrived, after they removed him out of the vehicle and placed him on the ground, are you specifically, do you mean the Mr. Floyd's actions, or
what did the defendant see when he first arrived on scene?
He saw Officer Landon King struggling with Mr. Floyd in the backseat of the vehicle.
Okay. And then what did the defendant do after he initially arrived on scene?
He went to assist those officers with attempting to place Mr. Floyd in the backseat of the vehicle.
And did you observe the body-worn cameras then of various officers at that moment that the defendant approached the vehicle?
Yes.
Okay. Describe what you saw as best you can recall when the defendant approached the vehicle.
They were attempting to place Mr. Floyd in the back seat of the vehicle. Mr. Floyd was actively resisting, moving around. He was attempting to get out of the back seat of the vehicle. Clearly, he didn't want to be back there. And the officers were trying to initially place him in the back seat, grabbing the seat belts and things of that nature. And then ultimately, the decision was made to remove him from the vehicle.
Okay. Now, at the point that Mr. Floyd was removed from the vehicle, right, when he was taken out of the vehicle and brought to the ground, do you recall what happened? How did the officers proceed to remove him from the vehicle?
Yes, so they were pulling him from the driver's side passenger door, which is the street side, and they were pulling on his legs and his arms, and once they got him out of the vehicle, they somewhat placed him on his knees, or he kind of went on his knees.
And so now getting back to before he was placed or who was attempted to be placed in the back of the vehicle, do you recall what Mr. Floyd was saying when the officers were trying to get him in the back of the vehicle?
Yes, he was saying that he couldn't breathe. He was saying he was claustrophobic, and that he didn't like being back there.
Did you see him, or did you hear him indicate that he had anxiety and that he was afraid?
Yes.
The answer is stricken.
And well, based on what do you recall Mr. Floyd telling the officers?
Numerous times he had stated that he was afraid. He had COVID before and he couldn't breathe, and he had anxiety, and he was claustrophobic.
Now, based on those statements and the way Mr. Floyd was acting at the time, do you believe that what the officers did to try to get him in the vehicle in and of itself was reasonable actions?
Yes, it could be perceived as reasonable, yes.
But were there other alternatives that they could have done besides trying to force him into the back of the car?
Yes.
Sustained.
Was it necessary for the officers to use force at that particular point?
Objection, cause for speculation.
Not necessarily, no.
What else could they have done?
They could have continued to try to verbalize with him. It appeared early on.
Objection, cause for speculation.
I said overruled.
Please continue.
It appeared early on that the Officer King had gained a slight rapport with Mr. Floyd early on, and so in police practices, it would have been best to try to continue to verbalize with him because he had gained a rapport with him, and try to get him to comply with his commands by verbalization.
But nonetheless, you believe, in your opinion, that it was not unreasonable for the officers to attempt to place him in the back of the car.
Correct.
And now I'd like to play a segment for you of what happens when they were getting him out of the car and initially placing him on the ground. So at this time, I'd like to publish the King body-worn camera, which is Exhibit 43. And I'd like you to please back that to 20, 18, and 46 seconds. Yep. All right, if you could play.
COVID, man, I can't breathe. Take a seat. Please, man. Please listen to me.
Is he going to jail?
Listen to me.
He's under arrest right now for forgery.
I tell you.
Can we figure out what's going on?
Forgery for what? Take him out. For what? Please, man. I can't fucking breathe.
Here, come on out.
Look at you. Thank you. Thank you.
Get him down on the ground. Yeah, on the ground. On the ground.
My wrist.
Right. And so at the point, then they decided to bring Mr. Floyd out of the car, and you could see on the video, Mr. Floyd was initially brought to his knees. Is that right?
Yes, sir.
And what did you hear Mr. Floyd say after he was initially brought to his knees?
I believe he said thank you.
And if you could continue.
Right.
You got your restraint? Hobble?
Okay.
I'll grab that. Get him.
Jesus Christ. I can't breathe. I can't breathe. Thank you. I can't breathe.
Stop moving.
Mama.
Stop. Thank you. Now, after he was initially on his knees and they began to put him to the ground, is that correct?
Yes.
What position did the officers place Mr. Floyd when they brought him on the ground?
Prone position.
And what is the prone position?
A prone position is where you lay a person on their stomach, chest area.
And you can see that Mr. Floyd had already been handcuffed, is that correct?
Yes.
Okay. And so at this point, he is now prone on the ground, handcuffed, correct?
Yes.
Okay. Prior to him being in this position, did you see any aggressive actions or what could be interpreted as aggressive actions on the part of Mr. Floyd?
Prior to the prone position?
Prior to the prone position.
Yes.
What did you see?
He kicked his leg.
And could you describe that kick and how that might be interpreted by a reasonable police officer?
Yes, so the officers were still attempting to control Mr. Floyd at the time, and as they were trying to place him down in the prone position, I believe one of the officers was attempting to control his legs, and Mr. Floyd kicked their arms away in an attempt to try to possibly break free from the officer's grasp.
Aside from that one kick, did you see anything else in your review of any of the materials, the body-worn cameras, that would constitute an act of aggressive behavior by Mr. Floyd?
No.
And that was at approximately, 2019 and about 35 seconds, is that right?
Approximately.
And when we are evaluating then the restraint period, this is about the time we're starting, is that right? Right after he was placed on the ground prone.
Yes.
Did you hear the defendant ask a question regarding a restraint at that point?
Yes.
And what was he asking about?
I believe he asked for the hobble.
What is the hobble?
The hobble is a restraint that's used to bind a person's legs in order to control them better and stop them from either harming an officer or breaking property. In most cases, kicking out the windows of police vehicles.
And if I can show you, show the witness and not the jury. One moment, Your Honor. Was that one received, Your Honor? 200. Oh. I'm going to ask you if you recognize what's shown in Exhibit 200.
Yes.
Does that appear to be the use of a hobble on a restrained person?
Yes.
Okay, I'll offer Exhibit 200 and ask to publish.
Any objection?
No objection.
200 is received.
And if you could publish, please. All right. Sir, is this the hobble restraint that you were referring to?
Yes, sir.
And when is this hobble restraint used?
Typically on someone who's actively aggressive towards the police.
And the person who you see in Exhibit 200, the hobble has been applied. What position is this individual in after this hobble has been applied?
The side recovery position.
What's the side recovery position?
The side recovery position is when you place someone on their either left or right side to assist them in being able to breathe better.
What's the purpose? Oh, I'm sorry. And you said it's to assist in being able to breathe better. Is that right?
Yes.
You familiar with the term positional asphyxia?
Yes.
What does that refer to?
It refers to when a person is in a prone position and while they're in the prone position, they have a difficult time breathing, and it may cause death.
Right. If you could remove Exhibit 200. All right. Now, once the officers had Mr. Floyd on the ground in the prone position, and you can see that he was handcuffed, and I'd like to bring Still image exhibit 255. That exhibit 255, that's approximately where we left off in the viewing of the video, is that right?
Yes.
Once that has been done, the officers here after the kick had an assessment to make, isn't that right?
Yes.
And that is whether or not they would continue to use the hobble or begin to use the hobble.
Leading is sustained. Rephrase.
What assessment did they have to make at this point?
Well, based on the defendant's request for the hobble, they had to assess whether to continue to apply the hobble to the Mr. Floyd.
Okay. And based on your review, did they do so?
No, they did not.
And what does that suggest to you regarding their assessment of the dangerousness or the need to restrain Mr. Floyd?
Based on my review, I would believe that they felt that he was starting to comply and his aggression was starting to cease.
And was that consistent then with your own observations of what you saw Mr. Floyd do as the video continued?
Yes.
One moment.
Let's shoot for 9:15. Members of the jury, we're actually going to break for the day. And the sergeant will be back tomorrow and we'll resume with his testimony then. Let's shoot for 9:15 again, so the normal process. All right, thank you.
All right, guys. Well, that's done. Let's see. All right, I'm gonna bring the camera back over here. So that's all done, guys. I'm gonna let you go. Today's been a long day for me, so we'll see you later on. I'm actually, you know what? I'm not gonna do a show tonight. I'm just gonna relax. Just not feeling it. So let everybody know that I'm not gonna do a 6 o'clock show tonight. I'll try and make a video real quick. So, all right, guys. And with that, we're gonna play Mr. Nice Guy's favorite and my favorite song. Right? Alright, guys.
EddieBlockFilms. You watching EddieBlockFilms. EddieBlockFilms. You watching EddieBlockFilms. EddieBlockFilms show. EddieBlockFilms. Watching EddieBlock, EddieBlockFilms. EddieBlock, the EddieBlockFilms show.